item 38 for an upgrade subject to your lordship's convenience.
How much time would you require?
For about 2 hours, my lord. I have
2 hours.
Yes, but I tell your lordship why, my lord. I have to cite 6 judgments, my lord. I have tried to, my lord, categorize my submissions under 5 or 6 heads, so I don't take your lordship's time. I've shown, my lord, the 2004 Act. Then I go to 2005 Act and, my lord, place my submissions. I have to show 5 or 6 documents, my lord, which are very small documents, 1 paragraph each.
See,
I'll try to compress as much as I can. I know, my lord, your lordships have large number of...
we have lost the luxury of long hearings.
But I'll try and be as brief as...
I wish
What I've done is
I can go on hearing and hearing, but
No, no, I
unfortunately the
But
docket
what
doesn't
I've done
permit.
is I've prepared a note. I'll take
Right,
your lordship's
right.
name.
So let us try to call up the matter anytime after 2:30,
Very well.
right?
I'll
So
be here.
2:30, 2:45, maybe 3. Then
Lordship.
we can give you the time for the rest of the day.
I'm very good.
Right?
I'll anyway, my lord, have the pleasure of
You
being
can
before
ask
your
one
lordship.
of your councils to be around if you want some time to go around the city. It's a good weather to go around, or you can...
My lord, I had the pleasure, my lord, of coming here in 2009 when, my lord, the Chief Justice was Justice Chalmeshwar, the lordship of the Supreme Court. I'd come on behalf of the union, my lord, to argue.
Right.
So that was the time when, my lord, one day, the lordships were sitting in a different combination.
Okay.
My lord, since then, my lord, I've been familiarized with this. But it's a pleasure to be before your lordships, my lord. It's a ever learning.
Up to you. Up to you.
I'm very grateful.
May I please, your lordship, I beg to mention item number 29, my lord. And that matter
29.
kindly be taken after 2 weeks. Here, my lord, office record is required, my lord. That's... I have already taken the consent of petitioner also.
29, and on the request made by Ms. Ega and CGC, matter stands deferred to be listed after 2 weeks.
Lordship, I did mention for listing my lord one for admission my lord.
What is the subject matter?
Subject matter is that the one penalty has been imposed on the delinquent lender.
It's for admission.
Lordship. Next week, my lord. On 20. Lordship.
Well, let it be on 26th. 26.
Lordship.
Please, your lordship. My lord, I have a prayer regarding item number 37, my lord. Lord, that conducting council has some personal difficulty, my lord. Kindly advise them.
37 on the request made on behalf of the council for petitioner stands deferred to be listed after 2 weeks.
Similar prayer for item number 4, my lord.
4. Have you informed the other side?
Yes, my lord.
Also 4. 4 and 37. Yes. Yes.
Bless you. May it please your lordship. Lordship, I pray for mentioning of an IA for listing your lordship on Monday. Lordship, the matter is about an order passed by your lordship on 23/7/2025, which was concerning of a promotion of a junior district administrative assistant to senior district administrative assistant. We were
Some
the
error.
respondents. Lordship,
Is there any mistake in the order?
Lordship, in the error we are concerned as we were the respondents, the promotion was given to us. So the petitioners in that case came up challenging our promotion, stating that we were given the promotion on the basis of a reserved seat for a reserve roster point when we were an unreserved candidate. However, that is not the actual case, your lordship.
Monday.
Monday, your lordship. Much obliged.
Motion, I think, one.
Yes.
Matter is posted for instructions.
Posted for?
Instructions, lordship, from the
Yes.
respondent.
My lord, I have been informed that the petitioner is under zone of consideration. Only the DPC has not been held. So, my lord, the office of PCCF has requested the departmental authority secretary to convene the next DPC as soon as possible to consider the petitioner's case.
In that case, a lordship may fix a time frame if possible, lordship. Because a time frame.
Give us something concrete.
Yes.
Next DPC. When is the next DPC going to be held?
May I pray, my lord, the matter may be fixed after 4 weeks, my lord. We will try to.
Because there's a letter already issued in page number 31, wherein it is said that on 3/1/2025 the DPC was to be held, but it could not be held. for the reasons best known to the respondents. And it is already after, almost after, already 7-8 months has gone. If they can provide a time frame that within so time they will hold the DPC, that will be sufficient, Lordship.
We'll have it after 4 weeks. Give them some time.
Lordship.
Third council for parties. Mr. I. Bothakur, Learned Standing Council Forest, submits that the petitioner is likely to be within the zone of consideration for promotion to the next higher post. And however, the process for initiating the promotion has not been undertaken. Therefore, the petitioner and therefore the respondent authorities will take appropriate steps to convene a proper DPC for selection and promotion to the next higher post, which is the post of
Deputy Conservator of Forest, DCF.
DC, Deputy Conservator of Forest. Stop. The Standing Council submits that matter be posted after 4 weeks, by which time any steps taken by the department can be placed before the court. Counsel for the petitioner does not object to the prayer made. List again after 4 weeks.
The Lordship may kindly fix a date so that I can inform the court dividing the DPC.
Fifteenth
15th.
September.
Lordship. How long is it?
God bless.
In this case, your lordship will dispose of, we are telling them a penalty of imposing of withholding of increment of 2 years with cumulative effect. Your lordship has come to a conclusion, my lord, that your lordship will kindly come to case 81 of the judgment, my lord.
Is
Page 81. Here it says that in absence of such materials, this court must conclude the inquiry report.
paragraph
Paragraph 17.
17. Okay.
In absence of such materials, this court must conclude that an inquiry report was not duly served on the writ petitioner. Copy of the inquiry report was served on the writ petitioner, indicates the inquiry report concluded petitioner is not guilty of the charge. Consequently, upon the petitioner being served with the second so cause, the question arose whether the disciplinary authority would disagree with the findings of the inquiry officer. So, if so, whether disagreement notes should have been served upon the writ petitioner. At this stage, this aspect need not be delved into further, as learned comment advocate fairly submitted the inquiry report available in the records. A word not has been struck out and was likely not a copy served to the writ petitioner. If that is the case, it must be concluded in accordance with the provisions of Rule 9A, Assam Discipline, the relevant judgment of appeals court, this petitioner was not served with a correct copy of the inquiry report. Consequently, petitioner was deprived of opportunities prescribed by law to ventilate his grievances. In light of the above, the respondents are directed to serve a fresh copy of inquiry report as found in the records of the department of the writ petitioner. Once the copy is served, the petitioner will provide with proper opportunities to represent before the concerned authority will file a statutory appeal. There, your lordship, I am agreeing. Because it has go to the disciplinary authority again. The disciplinary authority has to again, I have to file a representation on the basis of the report submitted to me. I have to file a representation before the disciplinary authority. The disciplinary authority will take a decision whether penalty can be imposed or not. And the impugned order has to be set aside. It cannot go.
What was the impugned order?
Impugned order was that there was a penalty imposed of a stoppage of increment for 2 years, man. That was challenged before this law, before this court, man. So it has to go to the not to the appellate authority, but to the disciplinary authority. Since disciplinary authority sees of the matter, because it will start from the stage of supply of inquiry report. So after inquiry report is served, the file is statuted. So question of filing a statuted will not be applicable, my lord. It has go back to the disciplinary authority. The disciplinary authority has to give a notice to me, and I have to file a representation before the disciplinary authority whether the charges have been made out or not, my lord. So on merit, the disciplinary authority has to take a decision, my lord. So it cannot go to the appellate authority. That is my submission. That part may be reviewed, my lord. And there is a yes, there is error apparent, my lord. The face of record. Since it was
Yes, Mr.
No, I have received instruction, my lord.
Huh?
I have received instruction in the review petition, my lord. Let me have this placed before your lordship by in the form of affidavit, my lord.
What affidavit?
But this instruction is but
matter of record. my
True
lord.
records, my lord. These other, my lord. He says, my lord, fresh inquiry report was not given.
Already direction has issued to give a phase inquiry report.
Needly give.
This, but we have that discipline authority will decide, not the appellate. The input order is 19/9/2012. That has to go, man. So for imposition of penalty of withdrawal increment for 2 years with cumulative.
This comment, continue. This comment.
We had sort of attempted to mold the relief.
I understand.
What
but-
we
but-
wanted to do is to give you the opportunity of the benefit of the inquiry report.
But that has to be decided by the disciplinary authority. Appellate authority cannot decide, my lord. Because the appel will come against the order imposed by the disciplinary authority. Because that has to go to, since it has goes to the stage of supply of inquiry report, so it has go to back to the disciplinary authority under Rule 9A, my lord. Last part, my lord, that some modification is required. And the impugn order may be set aside, they may take my representation and apply their mind and pass necessary order.
Mr. Sutia?
Let it be a lot sent back to the there, disciplinary authority.
Heard. Counsel for parties. This review application is directed against the order dated so and so, passed in WPC so and so. Stop. Petitioner, review petitioner before this court as a petitioner has assailed the order of imposition of penalty by the disciplinary authority on the ground that the inquiry report served on the petitioner revealed that the inquiry officer concluded that the charges leveled against the petitioner were not proved. Stop. He therefore it was therefore submitted before this court that before the disciplinary authority imposed the punishment on the petitioner, it was incumbent on the disciplinary authority to issue a disagreement note under Rule 9 capital
9A.
of the Discipline and Appeal Rules. So, as the disciplinary authority in the impugned order had clearly reflected that it had agreed to the findings of the inquiry officer. Stop. If that be so, and in view of the fact that the inquiry officer concluded that the charges against the writ petitioner did not stand proved, there was no occasion for the disciplinary authority to agree with the findings of the inquiry officer and also impose punishment by the impugned order. Stop. Whereas during the course of the hearing, the records were called for, and upon perusal of the records, it was seen that the inquiry report which came to be served on the petitioner and the inquiry report available in the records were at variance. Stop. The inquiry report in the records revealed that the inquiry officer concluded, inquiry officer in a sense, concluded that the charges have been proved. Stop. However, in the copy which was served on the writ petitioner, it appeared that the conclusion of the inquiry officer was in favor of the writ petitioner, holding that the charges were not proved. Stop. Under such circumstances, this court allowed the writ petition, directing the respondent authorities to serve copy of the inquiry report available on the records on the petitioner, and further directed the inquiry to proceed from the stage of service of inquiry report on the petitioner. Stop. While concluding in the judgment under review, it was mentioned that after service of the inquiry report on the petitioner, it will be open for the petitioner to file a statutory appeal. Stop. The review petition has been filed, projecting that the para 18 of the judgment under review clearly reflects an error apparent on the face of the record, inasmuch as since there is a specific direction for service of inquiry report on the writ petitioner and a further direction to the respondents to continue the proceedings from the stage of service of inquiry report, the imposition of punishment ought to have been set aside, and which was not done. Stop. Under such circumstances, this review petition has been filed seeking review of the judgment. To the extent it concludes that after service of the inquiry report, the petitioner will be preferred to the extent that the imposition of punishment was not set aside. Stop. Para. Learned counsel for the petitioner as well as for the respondents have been heard. The judgment under review has been carefully perused. Upon due consideration of the submissions, it is seen that para 18 of the judgment needs to be properly clarified. Stop. The conclusion arrived at by this court in the judgment is that the copy of the inquiry report available in the records were not served on the petitioner. Stop. And the respondents were directed to continue the proceedings from the stage of service of inquiry report on the petitioner. Stop. If that be so, then the impugned order dated so and so.
99.
Sorry?
99 2000.
99
2012.
2012, imposing a punishment of stoppage of increment for
2 years with cumulative effect.
2 years with cumulative effect
2012 punishment.
is required to be interfered with.
Did not,
Stop. It is accordingly interfered with. The matter will now proceed from the stage of service of the inquiry report on the petitioner. And thereafter, the petitioner may file necessary representation before the disciplinary authority. And the disciplinary authority thereafter will pass necessary orders as per the prescription in the rules under Rule 9
And
and 9 capital
Assam Disciplinary Appeal.
of the Assam Discipline and Appeal Rules 1964. Stop. Even
Earlier-
after,
Earlier
if,
occasion, my lord,
if the disciplinary authority passes an order adverse to the petitioner, the provision, the remedy of statutory appeal will also be available to the petitioner. Stop. Better. The review petition is therefore allowed to the extent clarified above. Stop. Para 18 of the judgment dated so and so, judgment dated 19/3/2025 is clarified in the judgment passed, in the order passed today. Stop. The order passed in the review petition is to be read together with the judgment and order dated so and so. Review petition allowed, disposed of. Yes.
the last occasion, the punishment was in 2012. He preferred appeal 2020. That's why they say it's a time barred. This time also, my lord, if suppose, my lord, discipline authority impose a penalty, he will have to go in time.
That is for him to decide.
That is the why, my lord, that was not done. Obliged, my lord.
Dispose.
May I please, Lord?
Yes.
Lord, the petitioner, my lord, was a sub-inspector, my lord, under CRPF, my lord.
Please,
In the year,
please, I'd like to submit your lordship.
Huh?
So DC Bora is on legs, your lordship. Can DC Bora, your lordship? Then legs, your lordship.
2015 matter, please call him.
Yes, your lordship, come, your lordship.
Please inform him.
Yes, your-
Yes, you can start.
yes. My lord, when his posting was at Gauripur, my lord, in the year 2008, my lord, he was subjected to, my lord, harass on several occasions by the assistant commandant, my lord. There is, my lord, specific allegation, my lord, against the respondent number 6 and 7. My lord, I have, my lord, made an complaint, my lord, before the higher officer, my lord. That is at page, my lord, page 31. I have explained, my lord, entire facts of the case, my lord. Page 31 is the complaint, which has been filed by the petitioner, my lord. And lastly, my lord, the shape 1, 2, 3, my lord. These are the bad remarks for a CRPF cadre, my lord. And he was
Who
lastly-
represents the other side?
my lord, the other side, my lord.
You have arrayed these
6 and
respondents
7.
by name.
My lord, the
Councils
my
appear.
senior friend, my lord, JC Bora, my lord.
He represents all.
Yes, my lord.
Yes.
And my lord, shape 1, 2, and 3. These are the bad category for a CRPF cadre, my lord. And if he or she declared as shape 1, 2, 3, my lord, these will, my lord, prevent the, my lord, promotion as well as the pensionary benefit, my lord, in the service level.
Where is the order? Where is the
My lord,
appeal?
page 19.
19.
Yes, my lord. This is the, my lord, shape. Shape 1, 2, my lord, I have annexed, my lord. 3 is not provided to us. Shape, my lord, S means psychological, H means hearing, A means appendix, P means physical capacity, and I means eyesight, my lord. He declared, my lord, this under the shape, my lord. And it will, my lord, hamper his promotion as well as his pensionary benefit, my lord. Even then, my lord, the specific allegation against those respondents, 6 and 7, my lord, I have categorically stated in my complaint, which has been filed before the higher authority, that is at page 31, my lord. Without, my lord, taking any action, my lord, with regard to my grievance, my lord, they only, my lord, issued a warning letter, my lord. That is at page 53. And my lord, my promotion is yet stopped, my lord. My colleague who were, my lord, promoted to assistant commandant, and still I am, my lord, in inspector. May I read my complaint?
Yes, yes, read.
My lord, page 31. Personnel grievance and problems. Sir, with due respect, IF/N number so and so SI Mustaq Ahmed beg your kind permission
So show
to
us the
submit
impugned
the
order,
RK
show us the
Sharma.
order 1210,
My lord, that is at page 53. 53, my lord.
Yes.
This is, my lord, information required under RTI Act 2005. Refer to your application dated 30/10/2009 on the subject. It is to inform you that allegations leveled by you against Sri R.K. Sharma, formerly Commandant 2nd Battalion CRPF, filed your application dated 18/6/2008, have been and required at director level, and officer has been issued a warning letter by Director General CRPF on 1/10/2010, my lord. Warning letter, but which is not, my lord, forwarded to us, or served to us. What kind of warning letter?
This is only a communication. You are praying for setting aside that communication.
My lord.
What is your prayer here?
Yes,
My prayer is, my lord, it will, my lord, clear my
What was
complaint.
the
My lord, page
punishment? What was
31.
the punishment imposed?
Punishment not imposed, my lord.
Then
But I was, my lord, subjected to harass on several occasions.
you file FIR
Sometimes
against
he
the officer.
referred as Bangladeshi, my lord, where when he joined in CRPF cadre, my lord, his credential was, my
These are
lord,
matters of
verified
fact,
two times.
require evidence. How do we decide this issue here?
cannot be decided by the state
And
court.
my lord, chef, my lord, chef 1, 2, my lord. These are the bad category, my lord.
My lord, his
Which has been, my lord, declared. Whereby declared the petitioner is, my lord, under chef 1, 2.
Where are the medical reports?
Medical reports, my lord, whereas, my lord, he is, my lord, fit for duty, my lord. Medical report starts from page, my lord, 19. This is chef, my lord. My lord, these are the chef, my lords. My lord, kindly come to page 23, my lord.
So you first explain us page 19.
Page 19 is, my lord, is my lord, original copy at page, my lord, 20.
You are
Annual
still in,
med-
you are still in service.
Yes, my lord.
You are still in
Yes,
service.
He's serving as inspector now, my lord. But his colleague, they were promoted to assistant commander. My lord, annual medical checkup and categorization, my lord. This was issued by the, my lord, medical CRPF medical officer, my lord.
Hmm.
He was, my lord, admitted in the CRPF, my lord, base hospital, my lord. And the doctors of, my lord, base hospital declared him safe to, my lord. Whereas, my lord, later on, immediately he, my lord, himself, my lord, with the help of his other persons, my lord, he admitted in the private hospital, in a government hospital, my lord, and he was, my lord, declared fit for duty, my lord. That is at page, my lord, 21. And original at page 22, my lord. Fit for duty at the same time, my lord. The base hospital declared him as a mental disorder person, my lord. At the same time, my lord, the government hospital, my lord, they declared that he is fit for duty, my lord. Duty, this medical, my lord, the base hospital, pursuant to the report of base hospital, my lord, the
What is
higher
the,
officer,
what is the procedure prescribed under the rules?
my lord, at the same time, my lord, he also checked up, my lord.
Procedure. Is there a procedure where you are required to be presented before the medical authorities?
That is, my lord, some officers, my lord, forcefully taken him to checked up in the base hospital. That is also
Yes,
his
respondent,
grievance.
what do you say?
That is also his
Lordship, may
grievance,
have
my lord.
come to our affidavit, my lord.
Hmm.
Just page 2, my lord, para 4, my lord. May I read, my lord?
Did you take any proceedings against him? Did you draw up any proceedings against him?
No, my lord, he is not a, he is mental, he has some mental issue, my lord.
You have stated he is a disobedient person.
Yeah, disobedient person also has some mental issue also, my lord. Lordship may come to page 6, my lord. What is his symptom, my lord?
He is still in the service.
In service, my
Yes,
lord.
If he is a person suffering from
Yes, but-
mental disorder, how are
At that
you
time- at that
availing
time, there
services
was
out of him?
some measure was taken, my lord. He was not provided arms, my lord. Some monitoring was also taken, my lord, at that relevant point of time.
Hmm.
My complaint will, my lord, clear everything, my lord, which has been, my lord, submitted before the higher authority, my lord.
Lordship may page 6, my lord. This is
And he is now, his
symptom, my lord.
posting is at
His
normal
symptoms, the
normal,
patient did not talk with
90.
anyone and remained lost and alone. On asking about the problems or anything in the general, either petitioner did not speak or speak very less, very casual in behavior. General moves
These are
around
the statement only, my lord.
aimlessly.
On what basis? Is there any medical report?
Yes, my lord. He was admitted in the, my lord, GMC, my lord.
Where is the report?
BMC, that is
That
clear.
report is not annexed with this petition, my lord.
On what basis have you written these findings?
Even, my lord, they also admitted, he was admitted in the GMC, my lord, in their pleadings.
This is your affidavit. Who has filed this affidavit? Is it by the respondents?
Respondent number 1 to 5, my lord, file this affidavit.
Who's respondent 1 to 5?
Union of Illinois.
So what do you want from this court now?
My lord, the shape 2 and 3.
How,
my lord,
how the
that-
court can direct whether you are in shape 1 or shape 2 or shape 3?
Lord,
You
if
have to
shape
be,
1 and 2,
it has
my
to be
lord,
decided by
remains.
the medical board.
Yes, my lord, my lord, respondent.
But your
authority
shape
to complete
today
the
and your
medical-
shape 10 years back will be
Yes.
different.
My lord, my promotion was, my lord.
Your
stopped.
promotion, you are aggrieved by, as you are overlooked for promotion 10 years back. 10 years back or 11 years back. What was your shape then and what is your shape now?
My lord, our grievance, my lord, is specific against the respondent number 6 and 7. My lord.
No, respondent, have you filed any FIRs? Have you filed any complaints against these persons?
Oh, yes, my lord. Before the departmental complaint that has been filed, my lord, that is page 31. But no action has been taken, my
That is
lord.
before the authorities. Where are you posted now?
Now at 9th mile, my lord.
Huh?
Guwahati, 9th.
Guwahati.
Only he get one promotion, my lord,
Yes,
from 2008 to as of now.
I have to take instruction.
after 10 years, after filing affidavit.
Otherwise, he has some mental issue at that 11 point of
Yeah.
time.
So
He was
mental
treated-
issue, you are engaging him in service, which is a good thing.
My lord. My lord. Gotcha.
You put him before review medical board, make his assessment, then if he's found suitable, you give him the promotions.
My lord, now, my lord, that was this incident related to 2008, my lord. Now it is 2025, my lord.
Even now, he is not being promoted.
Now he is promoted, my lord.
What
Only
rank are
one
you?
promotion. He get only one promotion, my lord. Sub-inspector to inspector, my lord.
And your
And his
colleagues?
colleague, they were, my lord, promoted to assistant commander.
My lord, at that time, his promotion was not considered due to his mental issue, my lord.
At present also, they are not considering my promotion, my lord.
Show us the rules for to be followed for consideration of promotion. CRPF.
My lord, if it come day after tomorrow, my lord, I have another books, my lord,
We are closing it.
voluminous book, my lord.
We are closing
Every
it.
rules is there, my lord.
We are closing it.
Today I have not taken, my lord.
Huh?
A voluminous book, my lord. In that books, my lord, every rules is there, my lord.
If you are aggrieved, you go through that voluminous book
Only, my lord,
before
day
the
after
appellate
tomorrow,
courts.
my lord,
Heard.
taken up.
No, we are closing it. 2015 matter.
My lord, there is a
2015 matter.
specific, my lord, provision, my lord. My lord, only 2 days, my lord. My lord, this matter is 2015, my lord. And, my lord,
Therefore,
only 2 days, my lord.
Therefore, we are closing it.
I will apprise, my lord, everything, my lord.
You listen to the
Only
order
2 days,
first.
my lord.
You listen to the order. Yes, anything more to be submitted?
My lord, only one thing, my lord. Lordship may come to page 4, my lord, para 8, my lord.
Page
Page 4 of my affidavit, my lord.
Page 4.
Yes, my lord. Affidavit of dated 21/3/2016, my lord.
Page 4 of
Affidavit in opposition 21/3/2016.
yes.
Last line, when the petitioner was posted in 2nd Battalion CRPF.
Last line.
Last line, my
Huh.
lord. Para 8, page 4, para 8, last line. When the petitioner was posted in 2nd Battalion CRPF, he has ignored the order direction of the then Deputy Commandant, the 2nd Battalion, and beaten up a civilians on the Naka duty on 14/8/2008, my lord. In the presence of the senior officer, hence the petitioner was awarded punishment of the severe censure by the Commandant 2nd BN in the orderly room on 16/1/2008 as per Rule 11(3) of CRPF Act 1949. Above punishment or the petitioner is proportionate to the gravity of the offense committed by the him, my lord. He was earlier also, some incidents was took place, that way he was punished, my lord. Subsequent to that, my lord, he has some family issue, my lord. Her wife, there is a miscarriage of her wife, my lord. Due to that, my lord, something might be happened, my lord. He has developed some mental issue, my lord. That's why initially he was referred to the CS hospital at Amerigok, my lord. And subsequently, he also treated in the GMC also, my lord.
All right. Heard Senate Council for Parties. This writ petition is filed by the petitioner who's serving as a sub-inspector of the CRPF, having force number so and so. At the time when the petitioner had filed his writ petition, he was posted in
Gauripur, my lord.
in Gauripur, in the
The Dhubri district.
district of Dhubri district in Assam. Stop. Petitioner is aggrieved by the fact that where is the impugned order? That letter,
That is page 53, my lord, the warning letter.
warning letter. He is aggrieved by the communication dated 12/10/2010, bearing number so and so, page number 53, whereby certain allegations leveled against the petitioner by the former commandant of the 2nd Battalion CRPF. And the same were inquired into at the directorate level. And the petitioner was issued within quotes, warning letter by the Director General CRPF on 1/10/2010. Stop. The petitioner has assailed this communication with a further direction, with a further prayer for issuance of a direction to the respondent CRPF authorities to take action and pass orders against the former commanding officer, Sri R.K. Sharma, and the Deputy Commandant Tejpal Singh Chauhan. Stop. These two persons are arrayed in the present writ petition as respondents 7 and
6 and
6
7.
respectively. Stop. The further grievance of the petitioner is that in view of these warning letter and being categorized in medical category shape 3,
Yes, my lord.
shape 3,
3.
Yes, my lord.
Roman 3, the petitioner was passed over and his juniors were promoted to the higher rank. Stop. As on date, according to the petitioner, he ought to have been promoted to the higher rank of what?
Assistant Commander.
Assistant Commandant. Whereas, because of the high-handed actions of the respondent authorities, he is still serving as a sub-inspector,
Now
CRPF,
Inspector, my lord. Now Inspector.
as inspector in the CRPF. Stop. It is submitted on behalf of the petitioner that this categorization of the petitioner in medical category shape Roman 3 is at the behest of respondents 6 and 7, who had misused their official positions and deliberately downgraded the petitioner's medical categorization so that he were so that his promotion, so that he was overlooked, as a consequence of which he was overlooked for the promotions to the next higher ranks. Stop. Learned counsel appearing for the petitioner submits that the petitioner had lodged complaints before the respondent authorities, including the Director General CRPF against respondents 6 and 7, but these representations had not been redressed and no orders were passed against the respondents 6 and 7, and nor his prayers for consideration for promotion to the higher rank was considered. Stop. Under such circumstances, the present writ petition has been filed. There are notice in this matter was issued as far back as 14/9/2015. Stop. The respondents have been represented by the learned CGC. As also the private respondents number 6 and 7. Stop. The respondents have filed their affidavits contesting the case projected by the petitioner before this court. Stop. In these affidavits, the respondents deny the allegations and the contentions raised by the writ petitioner. Stop. The learned counsel representing the respondent submits that the petitioner was in view of the petitioner had ignored the direction of the then deputy commandant during his posting at in the 2nd Battalion CRPF. And as a consequence thereof, he was awarded punishment of severe censure by the commandant 2nd Battalion in the orderly room on 16/10/2008, as per Rule 11(3) of the CRPF Act, CRPF Rules 1955. Stop. The petitioner is found to be a disobedient person, and as per medical reports, is found to be suffering from mental disorder. Stop. Under such circumstances, he was categorized in shape Roman 3, and therefore he falls short of the requirements for being eligible for being considered for promotion to the next high post. The counsel for the parties have been heard. The pleadings available on record have been carefully perused. So the limited grievance of the petitioner is that the communication, impugned communication dated so and so, whereby a warning letter was issued to the petitioner, is sought to be interfered with. Stop. The respondents, although have filed their affidavits, have not enclosed or referred to any proceedings undertaken for issuance of the warning letter. Stop. This warning letter enclosed to the writ petition as Annexure F appears to have been obtained by the petitioner by an application under RTI Act 2005. Stop. The petitioner is agreed that this warning letter has never been served on the petitioner by the authorities, and a copy of the same has been made available to him only upon an application under RTI. Stop. The affidavits also do not disclose any material that the petitioner's case was considered for promotion along with other similarly situated candidates, and having found to be unsuitable, he was not granted the promotion which he claims to be due to him. Stop. It is also not disputed by the respondents that in terms of seniority, the petitioner is otherwise not entitled to be included in the zone of consideration for promotion to the next higher post. Stop. Insofar as categorization of the writ petitioner in shape Roman 3 is concerned, the pleadings available before the court do not reveal the report of the medical professional or the medical board to which the petitioner may have been subjected to, and which subsequently categorized the petitioner in medical category shape Roman 3. Stop. The CRPF Act 1949 and the rules framed thereunder, more particularly the rules, have elaborate provisions and procedure prescribed for promotion to the higher ranks. Stop. Rule 55 makes it clear that all promotions shall be governed by merit. And where merit is equal, seniority shall count for promotion. Stop. For promotion, a member of the force must be qualified and recommended by the commandant, assistant commandant, or the company commander, as the case may be. Stop. There is even a provision for promotion of an unqualified head constable to the rank of a sub-inspector, or an unqualified sub-inspector to the rank of an inspector, with the prior approval of the Deputy Inspector General or Inspector General respectively, provided such promotions in either case do not exceed 10% of the sanctioned strength in such cases. Stop. The pleadings which are available before the court, including the affidavits filed by the respondent authorities, do not reveal the procedure which was adopted, do not reveal whether the petitioner's case was considered for promotion, and obligor the procedure adopted for due consideration of the claims of the petitioner and other similarly situated persons, and the conclusion of such departmental promotion committee, conclusion of such selection committee for promotion. That the petitioner is found to be unfit for promotion. Stop. During the course of the hearing, the learned CGC submits that the petitioner is still employed and is given duties which do not require the petitioner to handle ammunition and arms and ammunition in view of the mental conditions reflected in the medical reports. Stop. Taking into consideration the submissions made, the pleadings available before the court, as well as the procedure prescribed under the Act read with the rules, this court, and as also the fact that the writ petition has been pending for a disposal since 2015, this court is of the considered view that ends of justice will be met if the writ petition is disposed of with a direction to the respondent authorities to re-examine the claims of the writ petitioner in terms of the procedure prescribed under the Act, more particularly under the rules of 1955. Stop. If the petitioner is found to be within the zone of consideration by way of his seniority, then a selection committee shall be constituted to examine the claims of the petitioner and for and for consideration of his promotion to the next higher post. Stop. If it is the view of the higher authorities in the CRPF, namely the Commandant or the Director General or the Inspector General of CRPF, that the medical state, the mental state of the petitioner does not make him suitable for being granted more responsibilities by way of a promotion, in that event, such conclusion can only be reached upon a proper medical evaluation to be undertaken by a review medical board to be constituted by the who is your local head? IGP?
GP, my lord, yes.
By the Inspector General of CRPF, to which his unit is under which his unit falls.
my lord.
And the medical review medical board will examine the will examine the petitioner thoroughly and thereafter place him in appropriate medical shape category. So, if it is found that the petitioner, as alleged by the respondents, is suffering from mental disorder, then that shall not be taken as a ground to discharge him from service or deny him of his lawful rights for being considered for promotion in appropriate posts as may be available. So, the law laid down by the apex court in Ravinder Dhaliwal reported in so and so in respect of persons suffering from mental disorder, which is to be considered to be a disability and is required to be taken care of by the employer, must be strictly adhered to. Stop. There are the directions above shall be carried out within a period of 4 weeks from the date of receipt of a certified copy of this order. Any proceedings that may be that the petitioner may be subjected to, including the review medical boards, the conclusions thereof shall be served on the writ petitioner. Stop. Writ petitioner disposed of in terms of the above.
Oblige.
I think
Back Razor Lordship, the matter may be adjourned for the time being as the petitioner advocate is on leave.
Tuesday next.
The judgment.
Yes, Tuesday. This matter be listed on 19th. 19th. On the request made by the counsel for the petitioner. Yes.
The matter pertains to keeping the petitioner under prolonged suspension, my lord. He was suspended on 10/4/2024. Now more than 15 months have elapsed. He is still under suspension. And on, my lord,
Who is for the respondent here?
the final
Forest.
department. Final department.
Forest.
No, my lord, the petitioner is under finance department. He was serving as the finance officer and if your lordship peruses the last few orders, they've been taking time and time.
Some affidavit has been filed,
No affidavit. I have filed an additional affidavit
additional affidavit.
to bring on record that after filing of the petition and after the prescribed period of 6 months as per their own OM, they are now reviewing.
Finance scroll. You wait for some time, let him come. Finance department scroll.
Item 7.
Whether pertains to my non-payment of the pension and even provisional pension is not paid, my lord. He
Why?
retired in my lord January 2023, my lord, on the allegation of a pending criminal case, my lord. No DP is initiated, my lord. Only a letter of hearing was conducted and no result is given.
Yes,
On behalf of Assam State Election Commission,
election commission. He's an employee of election commission.
pending counsel.
You are employed
He
under
was election branch. He was serving in election branch.
election branch.
Yes, but GAD is the my lord main respondent, my lord.
No, you are employed under which department?
My lord, in the circle office, my lord, GAD department, my lord. Under GAD, my lord.
You are appointed under GAD.
The GAD department, my lord.
Who placed you under
In
suspension?
the, my lord, Deputy Commissioner Office, my lord. Deputy Commissioner Office, my lord. Pujai, my lord. And he was.
Yes, what do you have to say? What is your submission? Yes, madam. What is your submission?
Time for this, 1 week, spend time for the.
The additional Deputy Commissioner, my lord, submitted the affidavit, my lord. Wherein, my lord, it is mentioned, kindly, my lord, for a moment, my lord, page number 46 of the affidavit, my lord. They have annexed a, my lord, letter issued by the Pension and Public Grievance Department, my lord. Paragraph, page number 46, may I read the first paragraph, my lord. And it starts from the, my lord. That as per notification dated so and so, 21/6/12, Government of Assam Pension and Public Grievance Department, the retired government employee against whom any departmental or judicial proceeding is continued, no DCRG shall be paid to him until the conclusion of such proceeding and the issue of final order thereon. The proposal for final pension is pending at DDO level, and the final proposal will be submitted to the pension sanctioning authority after outcome of the criminal case.
Yes, who's representing the district commissioner?
Lordship, I am present.
What do you say?
So instruction here to receive, Lordship.
Some affidavit is filed.
Affidavit file, Lordship, but some queries made, Lordship. That's why some instruction is required, Lordship. That instruction not come, Lordship.
What instructions?
Lordship, regarding the pensionary, the criminal, the DCRG, Lordship.
DCRG, my lord, gratuity, if the provisional
Date
pension-
come retirement gratuity has not been released, Lordship. That instruction I have to obtain, Lordship.
my lord, calmly come to the page number 49 of their, my lord, letter based on which the affidavit is filed, my lord. Page number 49 is their letter, my lord.
Yes.
Based on this, the affidavit is filed, my lord.
Hmm.
My lord, in pursuance of the approval of the cabinet held on 7/6/12, the governor of Assam is pleased to order that henceforth all administrative department and head of the department and head of office of district shall issue provisional pension, provisional family pension and DCRG in all retired government employees of the state government as admissible soon after their retirement till the final PPO is issued by the Accountant General, Assam, and the Director of Pension, Assam, as the case may be under provision 22(1) of the Assam Service and Pension Rule 1969. It is clarified that the retired government employee against whom any departmental or judicial proceeding is continued, no DCRG shall be paid to him until the conclusion of such proceeding and the issue of final order. So, my lord, for the sake of argument, if it is admitted that the departmental proceeding is going on or continued, only DCRG can be upheld, my lord, not the provisional pension, my lord. It is in the first paragraph, it is clearly mentioned that soon after the retirement, the provisional pension should be paid, my lord. He retired, my lord, in January 23, my lord. Now in August 25, till date, the provisional pension not released, my lord.
Yes.
I obtain instruction also.
How much time do you want?
3 weeks notes.
3 weeks.
3 weeks notes.
My lord, may I submit in the same case, my lord, the other employee, my lord, against whom, my lord, the main, my lord, case is there, my lord. He has been, my lord, he has accused this honorable court. This honorable court, my lord, the very first day, my lord, granted him provisional pension, my lord. So kindly for a moment. He was the main person, my lord, against whom the allegation of taking bribe was there, my lord. He was the Lot Mandal, and in the social media, one viral video was there that the Lot Mandal was accepting the bribe. That person had refused this honorable court, my lord, and this honorable court, on the very first day, granted the provisional pension, my lord.
Here it was not granted. You did not pray for it on the first day.
My lord, I had paid, but they had sought for instruction, my lord.
Whatever.
Then after
Did you produce this order on the first day?
Yeah, that is, my lord, not for this. But
Today is not the first day.
but my your lordship is, my lord, can my lord pass an order for?
Of course we can, but let him get the instructions as to why, what has happened.
But in earlier occasions also, my lord, on the final
Give him
occasions,
a fixed date.
and since the affidavit is filed, my lord, already, my lord, the
You
affidavit.
get your orders, get your instructions quickly. You can't keep on sitting over it. Is the GAD also required here?
No, not the district commissioner is the main necessary party.
District commissioner is a party.
It's a major party.
You are representing whom?
Lots of respondent number, lots of 3 and 4, lots of
3 and 4.
3 and 4. And two also. 2, 3 and 4.
2, 3 and 4. So it's the district commissioner who has placed him under who has stopped it.
See, represent respondent of 5 lots.
What has 5 got to do?
Election official lots.
What is your role? I'm asking you. How are you connected with this order challenged? All right, third counsel for parties, Mr. A. Chakraborty, learned government advocate, prays for further time to complete his instructions regarding release of DCRG.
DCRG lots.
DCRG. He submits that his instructions, he may be permitted to complete his instructions on this list again on 27th
Lots.
August.
Lots.
22nd August.
Lots.
Ms. So-and-so appears for election officer
My lord,
respondent 4.
My lord, my friend did not take any regarding provisional pension, my lord, because as per letter, my lord.
Including provisional pension.
Provisional pension.
Will obtain instructions with regard to release of DCRG as well as provisional pension.
Lots.
Timing I think 6.
Yes, suspension again.
Lots.
What has happened? The services manual conduits. Some services manual.
May I please the facts, sir?
No. Yes.
May I please the facts, sir? Yes. Hello, while serving as the financial,
Hello.
while serving as the finance advisor in the office of the principal chief conservator of forest, the petitioner was apprehended in connection with ACB PS case number 27 of 24 on 18/3/2024. As is period of detention exceeded more than 48 hours, he was placed under suspension by invoking Rule 6(2) of the Assam Services Discipline and Appeal Rules 1964. The suspension order was issued on 10/4/2024. So by now it had more than 15 months have passed. My lord, he has not been reinstated, neither the suspension has been revoked. However, my lord, in the meantime, on 26/4/2024, memorandum of charges was issued to him, initiating disciplinary proceeding. That is also pending, my lord. No outcome of the disciplinary proceeding. And as per their own OM, even if a memorandum of charges served within 3 months of suspension, then also, my lord, within 6 months, review has to be done for extending the suspension or revoking the suspension. That was not done. We filed a writ petition assailing the suspension order. Thereafter, after passing of the 6 months and after filing of the writ petition for the first time in the month of December 2024, they, my lord, reviewed the suspension order, which I brought by way of an additional affidavit. And these are the facts, my lord, under which I am praying for cancellation of the suspension order, as it was not reviewed or extended within the stipulated time. my lord.
What about proceedings? Departmental proceedings?
Proceedings, my lord, I was called, my lord, thereafter nothing. Totally in dark.
You have filed your written statements.
Yes.
Thereafter, nothing. Yes, Mr.
Lordship, his suspension was reviewed on 3 occasions, Lordship. One on 6/12, second 12/3/2025, and latestly, Lordship, on 31/7/2025. So presently, he is under suspension, and his suspension was last extended on 31/7/2025.
These copies are not served on him.
Yes, it was served upon him, Lord.
Served on him.
Yes, Lord.
I brought the first review by way of the notice.
So what is the stage of the departmental?
Lordship, so far my
proceedings?
instruction is concerned, IOP has already been appointed, Lord.
Hmm?
He has filed his reply. Thereafter, IOPO were appointed, Lordship. Now the DP is going on, Lord.
No, you said it was not reviewed.
Yes, it's beyond time. It was reviewed, but beyond time.
No, your suspension was 10/4.
10/4. DP initiated by so-called notice on 26/4/2024, within 3 months. So as per their own OM dated 4/2/2020, still they have to review it or extend it by a speaking order within 6 months. So that 6 months expired in the month of October, and they have reviewed it in the month of December. After expiry of the 6 months.
Why was it not reviewed earlier?
Yes, that delay, Lordship, I accept, Lordship. But first time he submitted his intimation, Lordship, on 29/4.
You're receiving your subsistence allowance.
Yes.
Yes, at the rate of 50%, not 75%. That also
Are you entitled to 75 now?
Yes, my lord, 15 months going on, my lord.
Oh. Then you have to give him that 75%.
Lordship, it was enhanced up to 60%, Lordship.
No,
No,
whatever is
70%, Lordship, 70% has also been enhanced, Lordship. 12/3/2025. Now he is receiving 70%.
No, my primary ground of challenge is the continuation of the suspension order. The Honorable Division Bench of this Honorable Court has already held. Prolonged suspension takes the color of punishment, which is not permissible.
So, but then you have to also give meaning to the rules.
Yes.
The rules,
Yes.
these rules have not been put to challenge. So therefore, on and off interpreting these rules
Yes.
without putting them to challenge would also not be very correct.
No,
You see, the rules are
here rule 6(2).
6(2).
Yes, because he was.
See, first, where is that suspension order?
My lord, suspension order is at page Annex 1, page 20, my lord.
Page 20,
20.
Rule 6.2. This is under 6.2.
Yes, my lord. Because his
He was at it.
detention exceeded
Under
more than
custody.
48 hours.
So,
May I read the rule, my lord?
yes,
Rule 6.2, suspension. A government servant who is detained in custody, whether on a criminal charge or otherwise, for a period exceeding 48 hours, shall be deemed to have been suspended with effect from the date of such detention by an order of the appointing authority and shall remain under suspension until further orders. Now, as your lordship note, the Honorable Supreme Court in the case of Ajay Chaudhary versus Union of India reported in 2015 7 SCC 291. It has categorically stated that the suspension order shall not survive beyond 90 days time if no review or extension is permitted.
No, that is not correct. That
However,
is not correct. For,
No,
so
Nebli-
far as Ajay Chaudhary, I'm just correcting lordship. So far as Ajay Chaudhary is concerned,
let us know where
it is mandatory for issuing the so cause within 3 months. For passing a reason order, lordship, no timeline has been fixed.
Exactly, I was coming to that only. He just-
Later, it is there in the rule, lordship. Manual is quite clear, lordship. So far as 6.1 is concerned, within 3 months, we are required to review the suspension. So far as 6.2 is concerned, there is nothing in the manual that we have to review. Or even we have to issue a so cause, or we have to issue a DP.
And that
but
fact,
division bench judgment has,
yes, because
Division bench only said 6.2 apply, Ajay Chaudhary applies in case of 6.2 also. But so far as that timeline is concerned, that is nowhere except this departmental OM lordship. That 6
That's
month
your
OM
own-
is only OM lordship.
that's your own.
But it is not there in the rule also.
but this OM is still in force.
OM is there, lord.
So you have to
That is the
follow
only
OM.
provision.
And
To be
penal
honest,
provision is
that is the only
prescribed.
provision.
Hmm?
But so far as rule is concerned, manual is concerned, so far as 6.2 is concerned, lordship, no requirement of issuing a so cause, no requirement of initiating a DP, no requirement of review of the suspension within a specific period, nothing. These all applies in case of 6.1.
If Ajay Chaudhary applies, then all these applies, my lord. If
No,
the
if
division
it-
bench has said that Ajay Chaudhary will apply to 6.2.
Ajay Chaudhary applied, but
No,
for
that-
reason order, no
Chaudhary,
time is
you
there.
have to read Ajay Chaudhary,
Yes, ma'am.
not just para 21.
Para 22 also.
You have to read para
Yes.
21, para 22.
Yes, absolutely.
So if
Not
you
saying
read para 22, and if you read para 21 and 22, then it doesn't specifically say that what happens after you serve the
That's right. To fill up the blank, my lord,
show cause notice.
that's why pursuant to this honorable court order.
The only option is that, only direction perhaps is that the inquiry should be concluded within a time-bound period.
Yes.
That we can direct.
My lord, thereafter, why they have then brought up the OM, my lord, if they are not following their own OM. And lordship knows, under the rules of interpretation of statutes, if a penal provision is prescribed, then the manner in which
That is
things
OM,
have
not
to
a
be done, my
statute.
lord, they are mandatory in nature, my lord.
Penal provision where?
Here in the OM,
What is the penal?
yes, lordship. Lordship will take up page 41 of the writ petition, Annex 7.
Hmm.
The OM dated 4th February 2020.
Yes.
Fourth para from the top prescribes the 6 months period. And my lord, the fifth para. Senior most secretaries will be held responsible if cases of suspension in their respective departments are not dealt with and reviewed accordingly.
Hmm. Then,
Some accountability is prescribed, my
all
lord.
right, we will consider that, but how does it help you to come out of your suspension?
It helps me because they have reviewed the first review was carried out beyond this prescribed 6 months, my lord. So there is violation of Ajay Chaudhary, there is violation of their own OM. And my lord, may I place the division bench judgment which says a prolonged suspension, my lord, takes the color of a punishment, my lord, which doesn't.
You have been suspended for how many months now?
Now 15 months, more than 15 months.
What is the duration of prolonged suspension? When do you consider a suspension to be prolonged?
My lord, when it is
Ajay Chaudhary was for years.
Yes, Ajay Chaudhary has 4
Lordship,
years.
in Ajay Chaudhary Lordship, search sheet was issued after 4 years.
Yes, my lord, it will be under faction.
We are not accepting your contention that
I-
15 months is not followed.
I agree,
The
Lordship.
question
But
is
there-
that the purpose of review,
Lordship.
you have to give some meaning to your rules and regulations. This is
Lordship.
3 months.
Lordship.
Why a review for 3 months is required? So that whether you can take whatever steps you want to take against this person, you are given 3 months. If you think, no, it is not complete, we need another
Yes.
few months, you go ahead.
Yes, that is there, Lordship. But this OM also, this definitely, this provides for taking penalty against the officer who failed to review within a stipulated period of 6 months, Lordship. But nowhere it states that just because it failed to do the review within period of 6 months, he will automatically be reinstated. That is not there.
That is, I am before his honorable court. And lordship knows, my lord, why suspension is necessary. My lord should.
See, the entire parameters are set by the rules.
Yes.
No one is put to challenge these rules. Not
Yes.
even that before the division bench.
Yes.
The rules have not been called.
Yes.
There has been attempt to interpret the rules. How do you interpret the rules without putting them to challenge? It violates the basic rules of natural justice. You're not giving the state the opportunity to defend their rules. And there is the challenge is to the suspension.
My lord.
And in the judgment, we end up interpreting the rules.
No, my lord, because
The
lordship is
rules,
on.
these are prepared by the authority who's reposed with the responsibility to prepare the rules.
True, man.
And this responsibility is not ours.
Yes, it's a legislative function.
But yes, we can, and where required, we can interpret them, but they have to be put to challenge. So
Yes, my lord, the authority after.
you build up a case and tell us that the violation of the OM is as good as violating the rules. Show us. You build up a case to say that
Yes.
whatever is absent in the rules is filled up by the OM.
Yes, it can always be, my lord, supplementary.
And a violation of the OM
Yes.
will in effect mean violation of the rules.
Because what is not there in rules always can be supplemented by.
Give us the material.
Yes, my lord, lordship, if you want that,
I don't want it. You
I
are
was
projecting
prepared
a
with all the
case.
suspension judgments.
No,
my
no,
lord.
I don't want it. You are projecting
Yes,
a
yes,
case.
I've
Then
understood.
you have to support it with your material.
Understood.
Have you filed your response?
If it is not yet filed, Lordship, I'm placing my instructions, 2-3 instructions.
You-
Lordship, I'm going to file my affidavit.
Don't take as long as the suspension. So file it at an early date so that we can proceed with the matter.
Lordship will grant me 3 weeks' time, sort of, within this period, I am going to file my affidavit.
Yes, Mr. Patwari.
If your lordship peruses the last few orders.
No,
the
it
same
was
prayer,
for,
my
the
lord,
direction
same
was for instruction only, Lord.
I heard Mr. J. Patwari.
Instruction I'm playing, Lordship, even my
prayer.
last,
Statutory proceeding, no specific.
Lordship,
direction.
my-
That's
my-
what I
Be
left.
Nayak Additional Advocate General for the state. The petitioner is before the court putting challenge to the suspension order dated.
10/4/2020.
Where is it? Page number
20.
10/4/2024. By which the petitioner was placed under suspension under Rule 6(2) of the Assam Discipline and Appeal Rules, 1964. The further case of the petitioner projected is that the office memorandum number so-and-so dated 4th of February 2020, which lays down the procedure, specific procedure for review of suspensions, has not been adhered to by the respondents. So, under such circumstances, the impugned order of suspension has been assailed, praying for a direction to set aside the same and to reinstate the petitioner. The respondents are yet to complete their pleadings and file necessary affidavit. Learned additional AG prays for 3 weeks' time. So, prayer made by the state is granted, and they are directed to file their affidavit positively within 3 weeks and before the next date fixed. Stop. It is also made clear that if the petitioner is entitled to be paid subsistence allowance at the rate of 75% of his salary, the same shall be granted to the petitioner without further delay. List again.
On 16th, Lordship.
Hmm.
16th, Lordship.
On
16. In the meantime, Lordship, if my friend want to file his reply, Lordship, he can all file.
16th of September.
Obliging.
Oblige.
It's 8 to 17.
May I please your lordship? Lordship, item 8, 12, 13, 14. Lordship, this matter is led by my senior Ken Choji. He is out of station, lordship. Lordship, may I kindly accommodate only for their lordships?
Yes.
Here, my lord, we have
Okay.
5 cases, 9, 10, 11, 14, and 16, my lord. These are separate issues, my lord. The issues are different, my lord. So, my case is that the petitioner has
You are appearing in which matter?
for 9, 10, 11, 14, and 16, my lord.
Yes.
So the 14, kindly see the item 9, my lord. 9, it relates to the suspension, my lord. The petitioner, he was suspended and that was stayed. That was stayed. And now, my lord, the petitioner, he has retired. My lord, retired compulsory, premature retirement has been given by invoking FR 56J. So this is related to this case, my lord, to my case. So another one, that is 10, item 10, it is also related to the
No, in view of the submission made on behalf of the learned counsel, what do you propose to do? Do you want to carry on or you want to argue the matter
yes.
on a different date?
No, I want segregation, my lord.
Segregation?
Yeah.
Oh.
So, my lord, separate hearing is necessary, my lord. So, item 14 and 16, my lord, mainly. This is relates to my termination, my lord. So, I am out of the job since September 2014. So, it may be hard early, my lord, in separate date.
No, what are the other matters?
Other matters relates to this, my lord, my termination. What? Yes.
I have set the advertisement for the of the director of LG. Lordship, item 12, 13. The lordship main issue regarding the coronation of director. Coronation of the director of LG Viega.
Okay, then
Then lordship, that advertisement is also
14 and 16.
item number 12 and 30. Once again.
so essentially you are challenging an advertisement for appointment of a director and also the superannuation age of the post of director.
Yes, lordship. I am inter order lordship.
Which is also challenged.
Yes, lordship, in item number 8.
Right.
And during the interim period, I have ordered the item. Yes, I have silenced the order I have issued.
Oh, you have got them retired.
Yes.
That's
After
What has happened?
after it, yes.
First you get an interim order and then you get them retired.
So what
Yes.
has happened in this matter, the challenge is that the petitioner in item number 8 was serving as the director. So on the ground that he had reached the age of superannuation, he was removed and then officiating director was appointed. The petition, we have challenged that, in fact, I had challenged that I should be appointed as the officiating director because I am the senior most faculty member in the institute. So that is item number 15. In the meantime, I think the petitioner, which my learned friend is representing, he is the next person. So we are the senior most faculty members. FR 50 notices under FR 56 were issued to both of us for compulsory retirement. Because once we retire, the only person who remains is the private respondent who is serving as the officiating director. That is under challenge by both of us. And I have also challenged his appointment as the since he has also challenged the appointment of the private respondent as the officiating director. That is why all these matters are tagged together. So perhaps they can be heard together because all the facts
Who
are.
is the private respondent here?
The private respondent number 6, your lordship, at number 15.
No.
He was serving as the officiating director. So when that was under challenge, your lordship, notices under FR 56 were issued to both of us. So that is under challenge. Perhaps 14 and 16, which my learned friend is referring to, that relates to his termination. That can perhaps be separated because there the proceedings are already complete. And it has nothing to do with the issue of appointment of the director.
Proceedings of what?
Disciplinary proceedings.
Okay. There is some interim order restraining issuance of the final order. in the
Interim
proceedings.
order I got in 9, 10 and 11.
Yes, my matters also, there are status quo orders.
Regarding the proceedings.
In one of
you are
them,
given the order of compulsory retirement.
against the order of it, because there was a status quo order passed on the first day. And in the other matter, while the matter was pending, a disciplinary proceeding was sought to be initiated. Even that was stayed by this court in an IA filed by him.
You want your matters to be segregated?
Yes.
Okay, which are the items?
Item, my lord, 9, 10, 11, 14 and 16.
You want to be you want the matters to be taken up today?
Today not, my lord, on 19, my lord.
Huh?
That may be fixed, my early date, my lord, supper.
Then why are you asking for segregation? If you are not ready to argue the matters today.
No. Yes, no, here, my lord, Mr. K.K. Manto led this case today, he is not coming.
Okay, when do you want your matters to be fixed? Have it on 26th?
Well,
26th? All right, all these matters we listed on 26th of August. As the learned senior counsels who are to lead the arguments in the matters are not available to address the court today. The counsels are in agreement that the matters can be heard on 26th of August. List accordingly. Interim orders where passed will continue. Mr. A.K. Dotto appears for the institute in all the matters.
Or in all of them. And
We are for
item 10 and 11, lordship, for private respondent.
Mr.
S. Sutrodhar.
S. Sutrodhar appears for
In 10 for 5 and 6
respondent 5 and 6 in item 10
and 11, 4 and 5.
and in item 11 for respondents 4 and 5. MS S. Borua appears for respondent 4 in item. You are for the government, central, state government. You give the numbers to the court master. Will record it. Yes, 26th.
Item 18. May I please, your lordship? Lordship, the petitioner here is wife of late Sarthe Fanshaw, retired senior Khalasi of NIPCO.
You try, why don't you go for mediation?
No, lordship, I have already received the gratuity amount.
You have received
We have paid them.
But
everything.
lordship, yes, but I am yet to receive the leave encashment, lordship.
So
That
go
was
and
never your
address-
prayer.
Yes,
Lordship, I
Mr.
will
That's not the prayer also in the writ petition also.
But I mentioned in the writ petition also in para 4
No, no,
and annex and
the challenge was only with regard to the
Recovery of amount.
excess amount of 635,
Hmm,
199.
hmm.
And that has been paid by our annexure A.
Annexure A.
To our affidavit in opposition.
Hmm.
That amount has been paid, A and B annexure.
Lordship, I'm anyway entitled for the unleave and the half pay leave for the leave encashment also.
You examine the matter, Mr. Senapati, and find out if there's any amount payable to her, release it to her. We will
Definitely,
refer
but it was never brought to our notice
So
also.
we'll record it. We'll fix it for mediation, and you see if you can have your instructions, you can close the matter on that date. Heard,
PP Gogoi.
Mr.
PP Gogoi.
P.B. Gogoi.
PP.
P.P. Gogoi, learned counsel for the petitioner, and Mr. D. Senapati, learned counsel appearing for the respondents. The grievance of the petitioner before the court was the steps, was the action of the respondents.
For recovering excess salary.
For recovering the excess amount of rupees 6,35199, which is considered to be the excess salary drawn by the late husband of the petitioner, late Sarthe Phangcho, during his service under the respondent's stop. During the pendency of the writ petition, the respondents filed an affidavit and enclosed an order dated 29/6/2018, whereby the amount of rupees 6,35,199 sought to be recovered was reviewed, and it was decided to exempt and relieve the recovery of the excess amount in terms of the judgment and order dated 24/1/2017, passed in WPC so-and-so, within bracket Sri Khogendranath Medi versus NEPCO Limited. So the counsel for the petitioner, however, submits that the petitioner is yet to receive
The leave encashment.
leave encashment in respect of the services rendered by her late husband. Stop. Counsel for the petitioner, on the other end, submits that this was never the prayer, specific prayer in the writ petition. Stop. Specific prayer in the writ petition, and therefore he has no instructions on this aspect in this regard. Stop. Para. Considering the fact that the petitioner is a widow and is before the court for orders and has approached this court seeking relief that the recovery for excess salary be interfered with, and the same having been duly considered by the court, by the respondent authority, Oman. We permit the respondent authority to complete their instructions as to whether any benefit under leave encashment in respect of a late husband, late so-and-so, is available and payable to her. If so, the respondents will take all steps required to release the same amount. Stop. Let this matter be, therefore, be placed before the mediation on 19th September. 19th September. Stop. The respondents, if in the meantime can examine the claim of the petitioner regarding the leave encashment. So,
Deeply obliged.
Also, here in this case, the petitioner was expired. I have to take instructions for substitute petition.
expired,
Yes.
when?
That have been not been, I have been informed, but I have not.
It is submitted by the counsel for the petitioner that the petitioner has expired.
Lots.
Stop. He has not received any instructions thereafter. He prays for 3 weeks' time to complete his instructions.
Right.
Mr. S.K. Chakraborty appears for the respondent FCI list after 3 weeks.
Deeply obliged.
Kindly case me adjourn for the timing.
We are sending it for mediation.
Yes, sir.
We'll send it for mediation.
Well,
We'll send it for mediation.
addition of Pathan. Agreeable. The question of law is involved, my lord, because the service of the deceased employee was never regularized. So,
He's asking for pension.
yes, pension. That's the thing. He may be entitled to DCRG, but my instruction is
Under
that,
the railways,
no, on
PWD.
PWD. I'm paying for the office of the AG.
Lordship, first thing, Lordship, he was appointed in the year 1998. So we never regularized any person appointed beyond 1993. That is one, Lordship. And secondly, Lordship, he was receiving salary as per the direction passed by the Honorable Court, Lordship. Second. So his wife now praying for family pension, and we have already decided that she is not entitled to family. Terminal case. So issue has already been decided in many judgments after this order.
Give us one judgment.
Today is matter for reference law. This is. It is a
Parties,
matter of-
counsel for the parties submit that question of law is involved in the matter as the claim of the petitioner is for grant of pension and other retirement benefits for the services rendered as a work charged employee or under the PWD department. Stop. In spite of rendering. This is, you are claiming on behalf of your husband.
Yes. Family care for family
As the work charged period of service rendered on the work charge category by the late husband of the writ petitioner. Stop. In spite of rendering more than 20 years of continuous service, the pension has been denied. Stop. Let this matter be listed for hearing on 26th,
26 Lordship, I will be opposed to.
28th.
28.
Until 21.
Mediation.
Hello.
Counsel for parties agree that the attempt can be made to resolve this matter in mediation. Matter be listed for mediation on 5th of September.
In this case, my lord, IA is pending, my lord, for implementation. For the first, my lord, AG to be implemented as respondent
This is
number
for
one.
what?
Eight, my lord.
What is your claim here?
Claim, my lord, non-payment of, my lord, family pension, my lord, compassionate family pension. During pendency of the writ petition, my lord, a provisional gratuity and provisional pension has been sanctioned, my lord.
So why AZ is necessary?
AG, my lord, final compensation family is, my lord, sanctioned by the AG, my lord.
All right, heard counsel for parties. This IA has been filed seeking implement of the Accountant General as
Respondent number 8.
as a respondent in the accompanying writ petition being WPC 5192 of 2022. Stop. The petitioner is claiming for compassionate family pension. What are you asking? What is your relief that you're seeking here?
My lord,
Direction for compassionate family pension
my lord, the death benefit as well as compassionate family benefit.
along with the benefits relating to the service
by her
rendered by the
husband.
late husband of the, your husband,
My lord, my lord.
late husband of the writ petition. Stop. It is the submission of the petitioner that the Office of the Accountant General is a necessary party as the matter relates to grant of pensionary benefits, and ultimately the same will have to be sanctioned by the Office of the Accountant General. Stop. It is submitted by oversight. The Office of the Accountant General could not be arrayed as a party respondent. Stop. Accordingly, the council representing the Panchayat and Rural Development does not object to the prayers made, as also the State Council representing the state respondents. Under such circumstances, the IA stands allowed. The Accountant General, Principal, what do you say? Principal Accountant General.
My lord.
Accountant General.
Accountant
Within
General.
bracket ANE, Assam, Beltola, Moidamgaon, is arrayed as party respondent number 4.
8. Respondent number 8.
Number 8.
8, my lord.
In WPC number 5192. Stop. The petitioner will file amended course title within 1 week, within the course of this week, before the registry. I stand disposed. In the accompanying writ petition, you write, in view of the orders passed in the I, Accountant General ANE is arrayed as party respondent number 8. Stop. Petitioner will file amended course title in the registry. Stop. Where issue notice to the newly impleted respondent. Stop. Steps to be taken by the petitioner within the course of this week by registered post AD as well as usual course. Or you can serve to the standing council.
Yes,
Steps be taken, steps be taken by within the course of this week by service of extra copies on the standing council for the Accountant General. So consequently, notices are waived, but extra copies be furnished within the course of this week. Let the matter be listed after 1 week.
Obliged.
May I please, Your Lordship? May I please, Your Lordship? Lordship, in this case, we have issued minor family pension to the petitioner, Your Lordship. Regarding unmarried, he has to apply for unmarried family pension before the concerned department. Your Lordship.
Yes.
Can the matter be sent for the mediation?
Mediation. All right. Matter be placed before mediation as executed by the council for the parties list on 5th of September. None appears when the matter is called up for the petitioner. None appears. None appeared when the matter was called up on 19/3/2025. MS Gayan, learner CDC appears for the state. Purely for the ends of justice, the stands deferred, we listed after 1 week.
May I please, Your Lordship? Here, my lord, the grievance raised by the petitioner has already been redressed. But there are some entitlement also, but for that, my lord, I am to approach by filing requisite application as well as certificate. So that liberty may be given to the petitioner, Lordship, and otherwise case may be withdrawn, Lord.
Yes, maybe.
Withdrawn, Lordship.
You withdraw, we'll dismiss
Lordship,
it.
Lordship. Lordship, Lord.
The counsel for the petitioner submits that the grievances rendered in the writ petition has been redressed by the respondents. Accordingly, he does not wish to press the writ petition any further. Writ petition stands dismissed on withdrawal. Interim orders, if any, stand vacated. So, closure of this writ petition will not debar the petitioner from approaching the authority for any other benefit which the petitioner may claim he is entitled to.
Respondent number 5.
Mr. J.K. Goswami for 2. Respondent 2, Mr. S. Dotto for respondent 1, Mr. R.
Respondent
Prabhu for
5.
respondent 5.
May I please, sir? My lord, the petitioner is a widow, my lord, the deceased employee who is claiming.
Mediation,
Maybe, my lord, it is file is now in the AG.
with the AG, very well, you see if it can be sorted out.
Maybe not, because the matter has
If
probably.
it is not, then it will come back.
Because he had claim for pension and other benefits. Up to your lordship.
Both parties submit that this matter can be referred to mediation. Accordingly, matter be placed for mediation on 5th of September. Mediation or at a special order as a cycle of mind. For hearing, I think hearing below. But once we started hearing the our mother told you. Yes.
This is matter pertaining to departmental proceeding. Penalty of reduction of pay 1 stage was imposed upon the petitioner. On the second last occasion, I think, my lord, there was some objections raised by the respondents regarding the discharge certificate that I submitted at the time of getting employment in the SBI. Now, there is a question with regard to my SC status. So, lordship was pleased to pass an order to take the instructions. My lord, I have taken the instructions, my lord. There were 2 discharge certificates of the petitioner. One was initially issued wherein his caste status was not mentioned. So thereafter, he, my lord, contacted the authorities, and the authorities corrected my lord, issued the second discharge certificate by correcting the same. So far as caste status of the petitioner is concerned, my lord, he already he was in possession of SC certificate issued by the concerned office in UP. Those also I have brought, my lord. My lord can have a look.
Just
Fine.
I say. Could you look down hearing and over?
Original.
Otherwise, we can start later. Yes.
Some amendment was found. That means was a conflict. So I have got the original caste certificates and 2 discharge copies, my lord, for your lordship's satisfaction, my lord. Although that is not the issue in the writ petition,
issue is with regard to whether the penalty imposed upon the petitioner was justified or not. And I have challenged on the ground of violation of principles of natural justice and perversity.
So, it is the objection raised by SBI
Objection during the course of the hearing.
that there are two different certificates.
Two different certificates. So how come in one there was mention of my category as SC and in the other it was not mentioned as SC? So I took the instructions from the client. The client says that first was issued without mentioning my caste status. Then he requested the authorities. Then authorities issued the second certificate, discharge certificate.
Let Mr. Who is appearing? Borua.
Mr. Borua, yes. He is not there.
N. Borua, SBI. Let him come.
Fine.
You can take back this for the time being.
Yes, ma'am. Oh, Lordship, delegated. Lordship, would it be intended to another date since he is also, I haven't talked with him, Milord.
All right.
Well, 19th, if possible, Milord.
It has to be later. 26th, 28th and
26th, my lord.
26th. All right. List on 26th. As prayed for by the counsel for the petitioner. কি করবো? এখানে ঘুরে দিও, take it up.
My lord, may I just pray one thing, that the adjournment may not be in my mouth, my lord, if possible. I'm sorry, my lord. Something else, my lord. Or Mr. Bush.
Matter be listed on so-and-so as counsel for SBI is not available.
My lord. Highly updated. Deeply updated.
Would you like
Grateful, my
to
lord.
begin now or
Yeah, I can. Seem to
Your-
be, well,
your counsels are not there with you? Is that going to be inconvenient for you?
yeah, I send them a message, my lord,
All right.
and even to the other side.
Or if you want, we'll wait for.
But I'm in your lordship, sir.
No, you tell us when you want, because we have now reached the hearing.
Yes, my lord.
Matters.
Well,
So
that's
if you
what
take
I
up
thought,
hearing
my lord, I
matters,
seem
then
to be in good luck, my lord, today.
right.
But it will not be proper to start without the other side. On this side, my lord, they'll come, my lord, but
So we'll take it up in the second half then.
lordship. Very great.
May I please, my lord? My lord, I'm praying that this matter may be fixed on 26th, my lord. By then, the original records will be available with us, my lord.
Yes, Mr. Kaushik.
My lord.
Lot of
Time has been taken by them for producing these records. Because Lordship directed it after hearing this matter after the land vote.
What was the issue here?
My lord, the petitioner was deprived for promotion for 6 years, my lord. All the 78 juniors, my lord, they have been promoted. In fact, after observing the minutes, the Lordship found that there is not even a consideration given to the petitioner, my lord. And their affidavit is absolutely vague, my lord. No reasons why he was denied promotion.
26th,
My lord.
as agreed to, as prayed for by the counsel for the respondents. List on 26th, enabling them to produce the relevant departmental records. List on 26th.
Grateful. Obligation. That's a claim of regularization, Lordship.
Claim of?
Regularization, Lordship. The petition has been working as a attendant cum sweeper, Lordship, at the Donka Mokum branch, Lordship, since 1998. Now, Lordship come to page 14, Lordship. The assistant branch manager also wrote to the head office that the post is lying vacant, so there is a need for the service, Lordship. And Lordship, the local staff association also wrote by page 16, Lordship, that the person is working, so he need to be regularized. Now, bank has a policy, Lordship, that will Lordship find at page 26.
26.
26.
Hmm.
So, so the journal office wrote to the branch, so various branch, Lordship, in the format to be that has to be followed, that will Lordship find in the same. And accordingly, his name was sent by the branch office, page 27. The last line also important, Lordship, page 27. In this case, we have to inform that he has been working in this branch as temporary general attendant since the permanent superior has expired in 1999. So since 99, I have been working. So my name was sent, they have to now take step, but nothing has been done. So I approached this court. Now during the pendency,
How were you appointed? Where is your appointment order?
Lordship.
Appointment order?
They have issued me I-card, Lordship, that will Lordship will find at page 11. And the working certificate, that is page 12.
But no appointment order.
No such, but I have been working, that is true, and that is that they have a policy to regularize, Lordship. Now, one thing,
Where
Lordship,
is that policy?
page 27.
57.
25, Lordship. I mean, this has been issued under a policy, Lordship. It says that as advised by the head office, please verify the position and advise us whether any sweeper general attendant is working in temporary capacity on a continuous basis in your bus to enable us to advise head office in this regard.
This is for regularizing or for removal?
Lordship, that's why they are asking for whether working in temporary capacity or, and that is why the name has been sent on the next page, Lordship.
No, they're asking you, see, the rule says monitoring of implementation of rule, of reservation, etc. Follow-up action. They're asking for details whether any person is working. Does it on the face of it signify it is for regularization?
Otherwise, they would not have stated in next page, page 27, if there is a permanent post and the person has expired since then has been working. The last line of that. In the pro forma they desire that my name has been sent, Lordship. The bank has filed an affidavit stating that since 2019, they have outsourced it. Now, whether, Lordship, that's PRSing case, whether an ad hoc can be replaced by another ad hoc.
Outsourcing is a different issue.
So they could have
Ad hoc
discontinued, they will continued with my Lordship.
They could have.
Lordship.
But
Lordship, in this regard, I would like to place two decision, Lordship.
no, first tell us what about the procedure, provision, rules, whatever is there.
They have not denied that my name was sent. They have a policy under that. Those things has not been denied in the affidavit.
Where is that policy? Is it there somewhere? Mr. Buragoy,
Lordship,
any policy?
there is no such policy, Your Lordship. What has happened in this case, Your Lordship? The head office has sought for the information from all the branches.
Why?
Your Lordship, to keep a record
For
that
what
how
purpose?
many persons are working in a temporary basis. And the petitioner herein, he is not engaged directly by the bank. He is engaged through an outsourcing agency, Your Lordship. So whatever payment has to be made is done to the outsourcing agency, and the outsourcing agency in turn makes payment to the petitioner or the workers, Your Lordship. There was no formal appointment.
This is your letter of the branch officer, page 27, branch manager.
Lordship, it is our letter, but here, Your Lordship, if Your Lordship,
Lordship, the para 8 of my petition has been dealt with, paragraph 17 of the counter affidavit. Lordship, I kindly peruse that paragraph 17
Of counter affidavit.
counter affidavit. They have not disputed. May I read, Lordship? That I do not dispute the abatement made in paragraph 8 that letters H and I were exchanged between chief manager, administration, region 3 and branch manager seeking details of sweeper engaged on temporary capacity to advise the head office. But till date, no decision to advertise, no any vacancy to. So they may not proceed with further with the regularize, but they should have ought to have allowed me to continue in my post. How can one ad hoc can be replaced by another ad hoc?
In the instant case, your lordship, no person has been appointed as a single individual, your lordship. The entire work has been given to the outsourcing agency to carry out the cleaning work of the branches of the State Bank, your lordship.
Where have you stated in your affidavit?
Your lordship, paragraph number 13, page number 7. Paragraph 13, page 7 of my affidavit, your lordship. If I may read, your lordship. That I say that in past the petitioner accepted engagement on daily wage earner or on temporary basis and said that he accepted such engagement, which was not continuous but was off and on with open eyes, and I submit that petitioner has not acquired any right of being regularized or absorbed in bank service. Furthermore, since April 2016, the petitioner is not even engaged by bank, even on daily wages, since he is being sent to branch by an outsourcing agency to perform the service of a sweeper. Hence, he is an employee or contractee of Messrs. Amaresh Kumar, sent to bank to carry out the service performed by a sweeper to clean the floor of the bank and to do other course. So since April 2016, your lordship, his service has been under a outsourcing agency.
What do you say to para 13?
Lordship, page 4 of my rejoinder, Lordship. It will be paragraph 7, continuing, Lordship. The second paragraph of page 4 of my rejoinder. The petitioner prior to the filing of this petition was paid 9,000 per month, which was transferred by the bank to his account, not through the any agency. And now the same has been stopped to deny the benefit of. After I filed it, petition, thereafter they discontinued, Lordship.
You show us the particulars.
Lordship.
Show us the particulars.
Lord.
You should
Let
have
me
been.
fi-
You should
Let
have
me
had
bring
it.
that through an affidavit.
Should have had it here with the reply affidavit.
Let me bring that, Lordship.
Counsel for the petitioner submits that we'd like to bring on the court materials to support his contentions that the petitioner was employed under the bank at the relevant point in time, and his salary and other allowances have been directly paid to him by the bank. Stop. He prays for 2 weeks. Time to bring them on record. Mr. H. Buraguni appear representing the SBI, appears for the represents the SBI. It's after 2 weeks. Yes.
Item 31.
Lordship has heard this matter on several occasions, my lord. It is regarding the stoppage of one increment with cumulative effect for 1 year only. In earlier occasions, Lordship has directed them to consider, if possible, the appeal part.
Lordship, status of the, Lordship, the direction was given to us that to, uh, uh, st- that to, obtain the instruction regarding the status of the appeal, Lordship. Lordship, we, wrote a letter to the authority, Lordship, but, the status, we have not received the status, till now, Lordship. Kindly fix the matter in the next week, Lordship,
Get the status of the appeal. by
Lordship,
2 o'clock.
tomorrow or day after tomorrow.
2 o'clock.
Any,
Why is it difficult whether an appeal is filed or not filed? Small instructions, you are deferring matters.
no, Lordship,
The earlier several occasions, they are
tomorrow, Lordship. Tomorrow, Lordship, I will apprise.
14th. We'll have it on 14th.
Lordship.
List on 14th and the request made by Mr. J.K. Goswami that enabling him to obtain instructions with regard to the statutory appeal stated to have been preferred by the respondents, by the petitioner. The status of the appeal be placed before the court on the next date fixed, list on 14th of August. Mr. D.N. Bhattacharya appears for the writ petition. Yes.
32, 36.
Lordship, may I pray for adjournment
Why?
next week, any date, Lordship?
Why?
Mr. Pine will address in this matter, Lordship, some
What are these matters?
Lordship regarding NRC service matter, Lordship.
Huh?
Regarding service, Lordship.
What service?
Any date next week, Lordship.
No, what is the matter? What is
So,
the
the matter pertains to termination, madam. There were junior
Oh.
assistants who were working in the NRC office. They were terminated.
All right.
Termination has been challenged.
32, 33, I am for the health parts, my lord. That in 2020, they are terminated, my lord. After serving for more than 4 years, my lord. 5 years already last, my lord.
28th. The
Madam,
request
can it be on
made by the
alternate?
standing councils for the respondents, matters be listed again on 28th of August.
Item number 34, there's an interim order of it.
Interim order where passed will continue. Yes,
Yes, Lord.
get the name
Oh,
of
like-
the council. No.
in 34, item number 34, I am for the response number 1.
Mr. A.K. Dotto appears for respondent 1 in item 34. Right? No.
May it please, Your Honor.
Yes.
So if your lordship will kindly recall, on the last occasion, when I was before your lordships on the 29th July, I had invited your lordship's attention to the ARA Act of 2004. I'm so sorry. That's it. My lord, it starts at page
Spider
157
of these compilation.
of the writ petition paper. For presently, your lordship may oblige me and kindly only have the writ petition paper.
All right.
So, my lord, I don't have to take your lordship to different volumes. I've sequenced it in that manner that I cause the least inconvenience to your lordships.
Page number.
Page 157, it starts, my lord.
Okay.
Page 176, my lord. I though placed it, my lord, I beg to, my lord, invite your lordship's attention again, only to pick up the thread from where I left.
Yes.
My lord, your lordship will recall that this was an act which was brought in by the state legislature in the year 2004
Yes.
for the purpose of catering to certain needs which were peculiar to the state in the rural areas. And they brought out, my lord, diploma, a full-fledged course of 3 years plus 6 months of internship, and restricted, my lords, and that's very important in my humble submission, my lord, their functioning, only to rural areas which are outside it is defined, as well as, my lord, the restricted the activities. So the restriction was twofold, my lord. On the area in the state, and 2, on the nature of practice. Your lordship now in that background has page 176. That's section 24.
Yes.
176, my lord, under chapter 9.
Yes.
Powers and functions of the rural health practitioners. The rural health practitioner shall be eligible to practice medicine and rural healthcare subject to the following conditions, namely A, that they shall treat only those diseases and carry out those procedures, which shall be outlined in the rules, so statutorily prescribed. They shall prescribe only those drugs which shall be outlined in the rules. They shall not carry out any surgical procedure, invasion, investigation, treatment, medical termination of pregnancy, etc., but shall confine themselves to such medical treatment and perform such minor surgery as may be prescribed. They shall practice only in rural areas as defined in this Act. They may issue illness certificate and death certificates. They shall maintain name and address, age, sex, diagnosis, and treatment records of all patients treated by them, and they shall not be eligible for employment in hospitals, nursing homes, and health establishments located in urban areas as general duty physicians involved in patient care in OPD, emergency, and indoor surgery. So, my lord, this is a statutory restriction. One more restriction, my lord, was that none of them shall use, and that comes out in the regulations, my lord. The regulations start at page 180. At page 183, my lord,
Yes.
was statutorily prescribed by way of regulations the appointment of a selection board, which will, my lord, select candidates. Then, my lord, eligibility is defined under regulation 3 within bracket small 2, Roman 2. But what is important in my humble submission is Roman 3, procedure for selection. Selection of candidates shall be done strictly on merit basis. My lord, the averment, which is, my lord, averred in the petition, and as the records would show that, my lord, in every district, the persons who had the highest of merits from amongst the applicants were selected. That's the averment, my lord. I'll show that. The merit shall be judged on basis of marks obtained by candidates in physics, chemistry, and biology in the qualifying examination at page 185. Then, my lord, the only relevant portion in these regulations are, my lord, page 201. This is part of, my lord, regulation 7. A, the successful candidate shall be eligible to practice medicine and rural healthcare in rural areas of the state of Assam only.
You're reading from page
200, my lords.
200.
Regulation 7, important. That is how it says at the bottom of the page. 3 lines. The successful candidate shall be eligible to practice medicine and rural healthcare in rural areas of the state of Assam only. They can only prescribe drugs that have already been indicated in Annexure 2 of the regulations framed by authority. So, my lord, no drug other than the one by the authority. C, no rural healthcare practitioner. No rural health practitioner shall use the word doctor before or after his name, but can identify himself as rural health practitioner or RHP. My lord, only in the lighter way, my lord. In the cost title, my lord, petitioner number 3 has mentioned doctor, but he is a PhD doctor. They shall be involved in implementation of national programs. Then, my lord, subjects to be taught, my lord, I had indicated that day, my lord, that these are the subjects. Then, my lord, please go with me to page 214, the curriculum.
Yes.
It's under section 3 of the regulations. The curriculum of diploma in medicine and rural healthcare is oriented towards training students to undertake the basic responsibilities of a physician of first contact, who is capable of looking after preventive, primitive, and curative aspects of health in the rural area. The diploma holder shall endeavor and become capable of functioning independently in rural environment, and she should be able to deal with common problems of health and disease in the rural population, avoiding non-essential details of specialization. They must know the gravity and seriousness of the disease so that they can refer patients to primary health centers or district hospitals as early as possible to prevent morbidity and mortality. So, my lord, the point of first contact to see that the state, my lord, in exercise of, my lord, its obligation under Directive Principles, Article 48, my lord, provides healthcare in rural areas, my lord, this was designed. The, my lord, examinations are at page 249. I don't want to detain your lordship. Now, my lord, page 271 is the first notice by the state inviting applications for admission into 3-year course of diploma. It was published on 23rd of June 2005 at page 271.
Yes.
Well, Lord, as I had indicated, there was only one institute at Jorhat run by the state, established and regulated by the authority under this act, which was imparting this, my lord, education. Then, my lord, I beg to invite your lordship's attention to page 293, the first of the sample appointment letters. My lord, why I'm pointing out annexure 11 is the fact that even after the 2015 Act, well, the letter of appointment has remained the same. This is dated 12th of June 2009. Mr. So-and-so, son of so-and-so, resident of so-and-so, in the district of so-and-so, has been engaged under the administrative control of the District Health Society for a period of 6 months from the date of joining to the post of rural health practitioner, subject to terms and conditions of contract. Her services have been placed at the disposal of so-and-so ST, Member Secretary, District Health Secretary, Joint Director of Health Services. Please compare this with, my lord, page number 340, which is the revised one. Annexure 17.
Yes.
So fortunately, one is on left side and one is on right side. And if the, my lord, pages in between are eschewed for the time being, your lordship will have a bird's eye view of the.
Is it?
Everything
You say
remains the same.
This is revised under what? Revised?
This is, my lord, order for contractual engagement as a community health officer under the 2015 Act.
Okay.
My lord, 3 facts here, my lord, and these are, my lord, admitted, or may I say not disputed. A.
Now, just 1 minute. This gentleman was earlier appointed as an RHP under the erstwhile act.
Well, moment I finish 2 or 3 documents, your lordship will get the link. What had happened was that after the judgment, which was delivered in October 2015, my lord, batches from 2005.
So I'm sailing with you. All I'm asking you is that this 340 was also a person who was appointed earlier as an
Yes.
RHP.
Yes.
This is just for my notes.
Yes.
That's all.
Now, my lord, the terms of contract, which is at page number, I was coming to that. My lord, I wanted to show a page earlier, 339. But, my lord, may I hold here and, my lord, take your lordship first to the 2015 Act.
Just 1 minute. Just 1 minute. Yes, please. Sorry. Yes.
No, not at all, my lord. My lord, between the petition was filed in 2005. The relief prayed was only to declare the act as unconstitutional. Affected persons not joined. I'm only mentioning as a fact. I'm not, my lord, even for a moment asking your lordships to go back into questions which are decided. I won't do that. 2. No relief prayed to stop the program. If prayed not pursued, not granted. 3. No relief prayed to have because by the time the petition traveled to a final hearing stage in the year 2015, batches from 2005-8 to 2011-14 had already completed. And I had given that figure to your lordship, my lord, in my list of dates. Your lordship will recall that by that time, the 7th batch had already passed out. They were registered. They were issued certificates. They were given contracts and they were employed.
Lord, what is the term in the subsequent act? You're appointed as a
community health professional. But my lord, what happens is this, my lord, that's why I'm taking your lordship straight away to that, my lord. So, my lord, admitted fact, and last admitted fact is that affected persons came before the court by way of an application.
Which court? This court?
This court, when it was considering the challenge to the act, this court declined that, my lord, application. Meaning, my lord, it's, my lord, an inferential submission that the court never intended, because it is not said in so many, to affect all those persons, my lord, who were already registered. Because, my lord, principles of natural justice, which are always present to your lordship, would have required your lordships to implement.
Already registered as RHPs.
Already registered as RSPs, 7 batch. We are concerned with 10 batches, 609 petitioners before your lordship. 7 batches by that time had, my lord, undergone successfully the course, obtained diploma, obtained registration, employed and started working. Some of them, my lord, the first batch had finished in 2008-9. So they were working by that time for 7 years. It's of course, my lord, a humane problem, my lord, with which I have come before your lordships. My lord, page 331. On the judgment being delivered, my lord, your lordships have noted the date of the judgment, my lord, which is date of 30-10-2014. My lord, at page 331, the Assam Legislative Assembly enacts this act, my lord. It is known as the Assam Community Health Professionals Registration and Competency Act 2015. My lord, 3 salient facts to be noted in my humble submission, my lord, at the outset, before I take your lordship to the provisions of this act. A, under this act, my lord, except these persons, no other person has ever been invited to become a community health professional, nor any advertisement is issued, nor any course is taken further by the state. Now, my lord, I read the preamble. An act to provide for, at page 332 top, an act to provide for registration norms and competency of the community health professionals after passing BSc community health course, and to give same status to students who have completed or have been undergoing diploma in medicine and rural healthcare DMRHC course in Medical Institute Joran with that of BSc community health course, to enable them to serve as paramedical personnel in the state of Assam. Preamble. whereas it is expedient to provide for registration norms and competency of community health professionals after passing BSc community health course, and to give some same status to students who have completed or have been undergoing diploma in medicine and rural health care in Medical Institute Jorhat with that of BSc community health course, to enable them to serve as paramedical personnel in the state of Assam and methods connected therewith and incidental thereto. Please have C, the definition, my lords. 2C. I'm sorry, I must also indicate 2B. Certificate means a certificate of registration issued by the Director of Medical Education, Research and Training, Assam, under Section 3 of this Act. Because Section 3, my lord, incorporates a deeming fiction. 2C. Community health professional means persons who have been registered as such by the Director and issued a certificate of registration in accordance with provisions of Section 3 of this Act. Over the page, my lord, your lordship will find 2D to mean course means prescribed paramedical course of BSc Community Health, or in short BSc CH, as approved by the Union Cabinet convened with a Government of India's letter dated 31/12/2030. So, my lord, the color or the flavor that was given was EHC, a Bachelor of Science, Community Health, which was a course approved by the Government of India in 2013. This course, admittedly, that's why I say no applications invited, no institution established to administer this course.
What was the course which the writ petitioners had undergone? Is it?
Yes, my lord, they had undergone Diploma in Medicine and Rural Healthcare. Well, in short, all capital DMRHC.
In Jorhat.
In Jorhat Institute, Medical Institute.
There is also reference to BSc Community Health course. Are any of the petitioners having that degree?
No, but my lord, what they did was, after the judgment, issued a notice, when I take your lordship to those 3 or 4 documents,
Right.
saying that you were already registered, you come, we are registering you straightway under this. They, my lord, that's why Section 3 I must place. Every student, one is, my lord, future after the act comes into force, and none till today are my instructions. Every student,
Yes.
who successfully completes the course from any institution permitted by the Government of Assam to run the course shall be registered by the Director at Directorate of Medical Education, Assam, Guwahati, and shall be issued with a certificate of registration as community health professional. So, my lord, that is taking care of persons who shall henceforth, after coming into force of the Act, completing the course. Now, kindly see 2. Students who have already completed. So, my lord, us, RHPs, or have been undergoing Diploma in Medicine and Rural Healthcare, batches 2012 to 16, 2013 to 17, and 2014 to 18, 3 batches. In the Medical Institute Jorhat, on the date of commencement of this Act, shall be deemed to have completed or have been undergoing, as the case may be, paramedical course of BSc CH for the purpose of this Act, and shall acquire the same status to that of BSc Community Health graduates, and they shall also be registered by the Director and issued with certificate of registration as community health professionals. So, my lord, first 7 batches, by virtue of this deeming fiction and their notice of 2015, they altered the registration from one as RHP to CHP, and with respect to the 3 batches which were undergoing, my lord, 2012-16, 13-17, and 14-18 as CHPs, provided that certificate of registration issued by the Director under this subsection to students who have already completed Diploma in Medicine and Rural Healthcare EMRHC course from Medical Institute Jorhat shall be deemed to have been issued by the Director with effect from the date of issue of their respective diplomas from the said institute. So, my lord, by this proviso, it gives retrospective operation to Section 3(2).
Yes.
to all those students who were admitted 2005-9 and the last 2011-15 batch. Now, please see Malot 4, and this is Malot, in my humble submission, important. The community health professionals may be designated as community health officers by the government and shall work at sub-center level and any such places as may be determined by the government from time to time. 2. Subject to the provisions of this Act and the rules framed thereunder, community health professionals shall discharge their duties and perform their functions as per competency mapping of BSc CH course approved by the Government of India. In particular and without prejudice to the generality of the foregoing provisions of subsection 2, community health officers shall be responsible for A. Assisting the medical officers as per competencies of community health professionals as laid down in section 5 of this Act, as and when called for in coordination of NHPs, management of ASHA training and other responsibilities under NHM, apart from overall administration and management of CHC, etc., and quality and protocols of service delivery being delivered to the CHC. So what has happened is, Malad, all these people who underwent this hard training, Malad, have been asked to do work of data operators in community health sector. Has been asked to do work of data entry and data operators. So, Malad, they are termed as CHP. Assisting the medical officers as per competencies of community health professionals as laid down in section 5 of this Act and well called for in organizing outpatient, OT referral, emergency lab service, guidance in treatment of ailments to PHC staff, coordination with referral institutions, planning, implementation of immunization services, organized training of health workers, implementation of health and other national programs, act as planner, promoter, director, coordinator, as well as evaluator, etc. Then please go with me to Malad. The eligibility at 337. I'm only inviting your lordship's attention to that they devised statutorily to have this course from 2015 onwards, but none except the petitioners included within this Act. That's why this eligibility, of course, we'll have to refer to in future. Then, Malad, please see page 339. Lordships have noted the date of this Act to be 29th May 2015. It was notified in the official gazette of this state. Page 331, your Lordship will be pleased to find the date. On 24th July, Lord, comes this order. In pursuance of Assam Gazette notification number so-and-so dated 29th May 2015 of the Assam Community Health Professionals. I hope I am with you, Lord.
Yes, yes.
Registration and Competency Act 2015. Those who have already completed diploma in medicine and rural healthcare DHMRC course in Medical Institute Jorhat are notified as community health officer. Please see, my lord. Lordships, pause here and see the definition at 332 community health professional. Subject to submission of certificate of registration as BSc Community Health Professional issued by the Director of Medical Education Assam, Vidya Section 3, they shall act as paramedical personnel as per provisions of this Act. Further, DHMRC passed out students working as rural health practitioners, RHP under National Health Mission Assam, are hereby redesignated as community health officer subject to submission of certificate of registration as community health professionals issued by the Director of Medical Education Assam. So on Malad, by virtue of documents, they showed that Malad, except the change of designation from RHP to CHO, there is no change. And they'll continue to work. And that is apparent from the fact at 342 are the terms of reference or the conditions. This is, my lord, part of an order which I placed, my lord, at 340 in comparison with the earlier order, which was terms of engagement. Now, please see, my lord, 341. Articles of agreement, I'm just reading the date to indicate that this is after the judgment and after this act. 20th of February, year 2016. 341, top, my lord, left-hand side. Terms of contract of engagement as CHO, not CHP. my lord.
What is this? Community health officer.
Officer.
Is there a term to that effect in the 15 Act?
The term, my lord, in my humble submission is, that's why I placed 2C. If your lordship will glance page 332 for a moment. Community health professional.
All right. That's the only term.
No. Then, my lord, please go to page 334, section 4. The community health professionals may be designated as community health officers by the government and shall work at sub-center level and such places as may be determined by the government from time to time. Subject to provisions of this act and the rules framed thereunder, community health officers shall discharge their duties and perform their functions as per competency mapping of BSc CH course approved by the Government of India. So here we find, my lord, the mention of CHO. Now, my lord, while this appointment or the terms of contract, my lord, were entered in true, at 342, these are the terms of reference for the post of rural health practitioner.
Yes.
The same terms, my lord, which were there, they didn't even change the nomenclature. And please come with me to page 344. This is, my lord, 20th of August 2016. Just above the name of and signature of the rural health practitioner and the district health society, my lord. E. Diseases that can be treated by rural health practitioner is placed at Annexure 1. Drugs that can be prescribed by RHP is placed at Annexure 2. Any other work assigned by the district health society. Now, please see the note. They will be able to treat illness, carry out different procedures, and to use different drugs specified in the regulation of the Assam Rural Health Regulatory Authority 2005 and not beyond that. Moreover, they are not allowed to handle medico-legal cases, post-mortem examination, but they will be able to provide first aid even to those medico-legal cases attending OPD emergency where there is no doctor. Dated 20th of August 2016.
This is a part of
the contract. Well, that's why I read the date, my lord, of the CHO.
But this is referred to as terms of reference for the post of RHP.
Yes. So, my lord, they continued everything.
So they're interchanging the terms.
Interchanging the terms. That's why, my lord, 340, your lordship will find the name Ashraf Kamal so-and-so, 20th of February 2016. His signature at 341 in the contract, 344, the terms of engagement or the conditions of practice. Now, my lord, what happens is, my lord, on 30th of October 2014, the judgment is delivered by this court, saying that we strike down here. My lord, on 12/2/2015, which is before the 2015 Act, the government of Assam, under signature of the Deputy Secretary, writes a letter to the Director Health Services Assam at page 348. After this, my lord, 3 more documents and I'm done with the facts, my lord. With, please see your letter dated 12/2.
340.
348 annexure 20. It is a letter of 6 November 2015. This is in reference to a proposal. It emanates from the Deputy Secretary to the Director Health Service. So, my lord, I assume, having regard to the subject. Subject regarding creation of post of RHP. Your letter number so-and-so dated 12/2/2015. With reference to your letter on the subject cited above, I am directed to request you to furnish a clear proposal with proper justification for creation of post of rural health practitioners, along with all relevant information document. Matter may be treated as urgent. Then, my lord, over the page, my lord, is the answer. 10th of March 2016. My lord, please see subject, proposal for creation. First cited reference is 6/11/2015, which is 348. Second is 14/12. I presume, my lord, must be a reminder. With reference to the above cited government letter and in continuation of this directorate proposal number so-and-so dated 12/2/2015, I have the honor to submit herewith the proposal for creation of the post of RHP as received from the Directorate of Medical Education Assam with their letters number so-and-so 18/1 copy for favor and information and necessary action of the government. Lord, oblige me by having just over the page 351. Name of the post. Please see, my lord, sorry, 421.
Sorry, come again. Page number
351.
Yes.
Lord, second column, 421.
Oh.
It is not a coincidence, my lord, it coincides with all those diploma holders, I'm sorry, my lord, who had passed out in the years in between 2005-9, the first batch, to 11-15, 462, out of which some had left by that time. There were total 462. The proposal was for 421. Who were engaged, continuing on contractual basis at a fixed pay of 30,000 rupees. 13, 1-3. So, my lord, a great pay band was devised at page 351. Pay grade, DA, house rent, medical allowance, and total emoluments at 28,110. Now, my lord, the 2015 was, my lord, if I may use the expression, my lord, a panic legislation is coming out from their affidavit. Filed in the Honorable Supreme Court, my lord, in those group of matters where the students first challenged this judgment, who were studying. But last time, my lord, your lordship had put a query to me that who went to the Supreme Court first? A, the students who were studying at the time when the judgment was delivered. Second was writ petitions filed here by those persons challenging the 2015 Act, which came to be clubbed. Those were by persons who had already undergone.
Students had gone directly.
Students had gone directly.
32.
No, SLP with, my lord, there is a provision where you can, my lord, your lordships are of course aware, my lord, permission to file special leave petition.
No, they had approached this court earlier.
No.
Students? No.
They went over. Then, my lord, please see this affidavit. At page 361, this is only, my lord, to note, this is affidavit, first affidavit dated 2nd March 2016. Page 364, your lordship will get the date. It starts at 357 at 361. In view of this judgment, last 3 lines, left-hand side, 361. In view of this judgment, the future of rural health practitioners who were working under NHRM, the National Rural Health Mission, and National Health Mission, and those who had already completed course but not yet appointed. And of those who are still pursuing the course after their admission till 2014 becomes uncertain. In the meantime, Government of India approved a new course called BSc-CH, course for the creation of a middle level cadre of public health professionals. As per guideline of the said course, the passed out graduates of BSc-CH course shall be appointed as community health officer in sub-centers. In view of the above, State Cabinet, in order to protect the future career of RHP as well as those who have already completed or still pursuing DMRHC course and who were admitted on or before the sessions 2014 to make their status same with BSc CH graduates, proposed for introduction of the Assam Community Health Professional so-and-so Act of 2015. Then, my lord, please see bottom of that page, last 3 lines of paragraph 6. I'm sorry, my lord, 3 more lines. On other hand, Assam Rural Health Regulatory Authority Act 2004 enabled diploma holders to independently practice modern medicine to treat common diseases within certain limitations. Therefore, the vacuum created by non-availability of registered medical practitioners in rural areas cannot be effectively addressed without permitting community health professionals to practice modern medicine to treat common diseases that are easily treatable at primary health level. So this is the declaration. From this and the subsequent affidavit, my lord, why I'm showing this is, my lord, I'm also, my lord, urging for your lordship's kind consideration 2 principles, my lord, one of legitimate expectation and one of promissory estoppel. Who, my lord, places submission for your lordship's consideration, and we found, my lord, palatable to accept it, that, my lord, the state once having declared, my lord, your lordships are aware, like an act of court will prejudice no one, and, my lord, act of legislature will also prejudice no one, provided, my lord, it can be shown that, my lord, the person who is under that legislature, my lord, acted bona fide. These persons acted bona fide, admitted themselves, gave up the other choices that they had when they were 18, 19, 20, my lord, and undertook this. Complied with the stipulations under the Act and got themselves registered. So in that context, my lord, these paragraphs become important. And, my lord, your lordship will only recall that under, my lord, list 2, which is the state list, my lord, entry 6 is public health of the Constitution of India.
Yes.
List 2, schedule 7, public health, sanitation, hospitals, and dispensaries. Then, my lord, to pick up my thread again, without permitting community to to practice.
Is there any question on the competence of the state?
No, there is none. They were working all throughout, my lord.
No, competence of the state. You're referring to entry 6, so therefore.
No, entry 6, Miller. No, this was only with respect to, my lord, showing that, my lord, when they made this solemn declaration, they had this aspect in mind. To practice modern medicine, that it is now opined that if after introducing the course of BSc, the graduates are not allowed to practice modern medicine, albeit in a limited way, then the intent and purpose of introduction of the short-term course would not be fully served. The state of Assam relies on dictum as laid down by this honorable court in Dr. Mukhtar Chand versus State of Punjab, which provides as follows. Because prescribing a drug is concomitant right to practice a system of medicine, therefore, in broad sense, the right to prescribe a drug of a system of medicine would be synonymous with the right to practice that system of medicine. In that sense, right to prescribe an allopathic drug cannot be wholly divorced from the claim of practicing allopathic medicine. Well, at some point of time, your lordship will recall, with your lordship's vast experience, all over India, there were doctors who were practicing, Ayurveda and Unani system of medicine, but they were prescribing, allopathic drugs. The question arose whether they can do it, and that ultimately landed up, in the Honorable Supreme Court from Rajasthan and other states, State of Punjab, and where it was held that yes, they can prescribe the drugs. It is this judgment. Then, Further, the state of Assam relies upon judgment as laid down by this honorable court in civil appeal so-and-so, Subhashish Bakshi. Well, that's the state of West Bengal, which has followed the judgment rendered by this honorable court, Mukhya Chand. State of Assam also seeks to bring to the notice of this honorable court the division bench of the Calcutta High Court in writ petition reiterated that persons holding diploma and employed to man the health centers and subsidiary health centers would be competent to treat common diseases among rural population, including communicable diseases, malnourished states, snake bite, insecticidal poisoning, etc. Well, comes the second affidavit, which is dated 12th January 2021. Starts at page 365. Well, my friend wanted to show me, but that paragraph, Malod, I can't possibly rely upon because they had that paragraph to say that we support the petitioners. As a matter of fact, the state should have challenges my own personal belief, Malod. It makes a Malod difference when a state legislation is struck down and the state is before a court as a petitioner. And Malod students, Malod, who were under that course, Malod. But Malod, that paragraph, Malod, I need not place in my humble submission. Please see the next affidavit 365. Well, by the time this affidavit was sworn in, there was a new act which came into force at the national level, which is, Malod, in place of the Indian Medical Council Act, the National Medical Commission Act 2019 was enacted by the Union Parliament, Malod, brought into force after having received the assent of Honorable the President, Malod, on 8th August 2019.
Yes.
So please first see 369 and then I'll briefly invite your Lordship's attention to two of the sections where the situation, according to me, if the state, in accordance with its solemn declaration, so chooses, my humble submission is that this court will be competent to issue that mandamus to the state. The NMC Act, internal page 5, running page 360. The NMC Act, which is this National Medical Commission Act, has been published in the official gazette on 8/8/2019 after it received the assent of the President. Therefore, while the different provisions of NMC Act came into force on different dates, only few provisions of the NMC Act 2020, section 3, 6, so and so, were brought into force. Well, that's a typographical error, 9299. In furtherance of the declared objective, section 32 of the NMC Act 2019 has provided for limited license to practice medicine at mid-level as community health provider to such person connected with modern scientific medical professional who qualify such criteria as may be specified by the regulations. The said provision also provided that community health providers may prescribe specified medicines independently in primary and preventive health care, but under other areas, he may prescribe medicine only under supervision of medical practitioners. Section 32 provides for a uniform regime of limited practice of modern medicine for community health providers throughout the country. Section 32 and all remaining provisions of the NMC Act have now been notified on 24/9/2020 with a notification number so-and-so, Ministry of so-and-so, Government of India, to come into force from 25/9. However, to the best of answering respondents' knowledge, the regulations have yet to be framed as provided therein. The criteria, contour of issuance to limited license to practice are to be specified therein. Para 7. The respondent state proposes to take up with the central government regarding framing of regulations for due implementation of Section 32 of the NMC Act, the petitioners herein CHOs, RSPs under the ARA Act 2004. Being connected with modern scientific medical profession definitely have acquired the requisite skills by their training and experience for limited license to practice medicine as community health provider. It is also the respectful submission of the respondent state that such limited license to practice medicine in primary and preventive health care needs to be liberally structured so that the scope of work practice for community health provider is wide enough within the permissible fields. The answering respondent state respectfully submits that the answering respondent would take action to align the responsibilities of CHOs with Section 32 of the NMC Act 2019 after regulations are framed, irrespective of whether the existing Act of 2015 continues to be in force or in the change scenario, this Honorable Court decides in favor of RR 2004. So, my lord, this is the solemn declaration. This is, my lord, in my humble submission, the basic, my lord, document.
This is the stand of the state.
Stand of the state,
essentially.
legitimate expectation, my lord. I invoke that principle as well as, my lord, promissory estoppel. Moreover, answering respondent submit that any decision of this Honorable Court in favor RR in present situation when regulations under 32 of the NMC Act are yet to be framed may lead to incongruent situation with two contradictory state legislations on the same subject matter. It is submitted in this respect that the matter has been considered minutely by the answering respondent, and it is submitted that in line with the consistent stand of the answering respondent to support the RHPs, the answering respondent has decided that the answering respondent may move a proposal for repeal of ACHP Act to address the anomalous situation. So they say, irrespective of this 2015 Act, in view of the NMC Act and Section 32, they are competent. Then, one last document, is 374. This is 3/7/2023. The judge.
(374).
I'm sorry, I dated 3/7/4, I'm sorry.
26 February.
26 February 2021. I'm so sorry. This is, the government order or the OM, or GO as we say, in pursuance of the cabinet decision in the meeting held on 27/12/2020, the government of Assam is pleased to notify the following benefits under the National Health Mission, Assam Employees Service Benefit Scheme, to the contractual employees who have worked continuously for 10 years or more with unblemished services under the National Health Mission Assam. For all of us get covered. This is how engagement in services till attainment of 60 years of age, continuation of service till they attain the age of 60 years, subject to annual appraisal, discipline, good conduct. In case of adverse appraisal, they can be released prior to 60 years. Employees will not be entitled to any kind of pensionary. Term of NHM employees who may subsequently complete 10 years of continuous unblemished service shall also be similarly extended. However, NHM employees will have to display efficiency, discipline, integrity, and also and so on, which is usual. My lord, I have invited your lordship's attention to the judgment, the conclusion. My lord, I would respectfully submit that in view of such declaration, my lord, and the Honorable Supreme Court, because, my lord, by that time a judgment had already come on the, my lord, effect of setting aside or declaration of law as invalid by a court. I'll cite the judgment 2022-19 SCC. There is no reference.
Guwahati High Court single bench had dismissed the petition.
No, Guwahati High Court had, my lord, with respect, allowed the petition and striking down the act on the ground of repugnancy.
2015 Act.
The 2004 Act.
4 Act.
Yes. My lord, I also indicated and taken your lordship to those paragraphs of the judgment where the Honorable Supreme Court does not agree with the reasoning.
Right.
The reasoning was that there is repugnancy in view of Article 254.
That is not accepted.
That is not accepted, but on different ground of legislative competence, the, my lord, final relief is upheld.
Who challenged this petition before the High Court? 2004.
My lord, the local branch.
So according to them, they are not qualified to be treated to be or treating patients or prescribing medicines, etc. Perhaps.
No, that was the ground. That was the ground. But, my lord, perhaps in my humble submission include the real intention behind was to see that, my lord, no other cadre which threatens their very existences my lord, comes into existence.
So the single judge coordinate bench had held that this is repugnant to the Medical Council Act.
In view of section 10A, which says that no new medical college or no new course shall be unless you have permission of the. My lord, it's difficult in time to travel back unless you have the time capsule. But my lord, perhaps the simplest answer at that particular point of time in my humble submission was that even under that act, they had the power that all right, ask the state to have it included in the schedule. That would have solved, my lord, perhaps the problem, my lord. But at times, my lord, we tend to go off tangent. My lord, we talk about on this side, my lord, in assisting your lordship, my lord.
We include.
No, I know.
both sides.
No. But 513. So it was in background of these particular facts, the NMC Act having come, the state of the stand, my lord. I would respectfully request your lordships to read the direction of the Supreme Court in para 26.25(4) at page 513. Because my humble submission is that this is recognized. This has to be read as prospective. Consequently, the subsequent legislation, namely the Assam Act 2015, that is the Assam Community Professional Registration of Competency Act 2015, enacted pursuant to the judgment of the Guwahati High Court, is a valid piece of legislation as it has removed the basis of the impugned judgment passed by the Guwahati High Court. The 2015 Act is not in conflict with the IMC Act 1956. This is because the Central Act IMC 1956 does not deal with community health professionals who would practice, please mark these words, my lord, for my purpose, very important, who would practice as allopathic practitioners in the manner as they were permitted to practice under the Assam Act. Assam Act is defined in section 2, and the only act, my lord, which permitted them to practice allopathic under the act, my lord, was the 2004 Act. In rural areas in the state of Assam, one of this 2015 Act does not permit. So, my lord, obviously, in my humble submission, the direction can only be read to mean that, my lord, all those people who have got these degrees, even if they are designated as CHO, their right to practice in rural areas, allopathic medicine is recognized by virtue of this direction, is my humble submission.
What was the conclusion? Can we come back to page 20, para 25 of the judgment?
Yes, my lord, of course. My lord, kindly oblige me and have page 509. In the result, we arrive at the following conclusion. Entry 25 of list 3 of 7th schedule of the Constitution of India deals with subject education, which is in concurrent list, under which both the Parliament or Union Legislature as well as state legislatures have legislative competence to legislate. However, entry 25 of list 3 is subject to inter alia entry 66 of the list, which is Union list. Entry 66 of list 1 deals with coordination and determination of standards in institution for higher education or research and scientific and technical institution. Thus, when any law is made under entry 25 of list 3 by state legislature, the same is always subject to entry 66 of list 1. In other words, if any law made by the Parliament comes within the scope of entry 66 of list 1, then the state legislation would have to yield to parliamentary law. Thus, where one entry is made subject to another entry, it would imply that out of the scope of the former entry, a field of legislation covered by the later entry has been resolved to be specifically dealt with by the appropriate legislature. 2. In the instant case, it is held the Indian Medical Council Act 1956 is a legislation made by the Parliament for the purpose of coordination and determination of standards in medical education throughout the country. The said law, along with rules and regulations made thereunder, are for purpose of determination of standards of medical education throughout India. Thus, determination of standards in medical education in India is as per IMC Act 1956, which is central law. This is in respect of modern medicine or allopathic medicine within the scope of entry 66 of list 1 and not under entry 25 of list 3 of the 7th schedule. Therefore, a state legislature which passes law in respect of allopathic medicine or modern medicine would be subject to the provisions of the IMC Act 1956 and the rules and regulations made thereunder. This would imply that no state legislature has legislative competence to pass any law which would be contradictory to or would be in direct conflict with the IMC Act 1956 and the rules and regulations made thereunder. In other words, the standard in medical education insofar as modern medicine or allopathy is concerned have been set by the IMC Act 1956 and the rules and regulations made thereunder, or by any subsequent act in that regard, such as the Medical Council of India Act 2090. Well, this is an error, Malad, typographical, inadvertent, NMC Act. There is no act as Medical Council of India Act. It is National Medical Commission Act. The state legislature has no legislative competence to enact a law which is in conflict with the law setting the standards of medical education in the context of modern medicine or allopathic medicine, which has been determined by the parliamentary legislation as well as the rules. In other words, a state legislature has no legislative competence to enact a law in respect of modern medicine or allopathic medicine contrary to the state standards that have been determined by central law. In view of the above conclusion, we hold that decision of the Guwahati High Court holding that the Assam Act to be null and void is just and proper. However, the Guwahati High Court has held that the state had no legislative competence to enact the Assam Act in view of Article 254 of the Constitution on the premise that IMC Act and the rules and regulations made thereunder were holding field, and hence on base of doctrine of occupied field, the Assam Act was struck down as being repugnant to central law. In view of the aforesaid conclusion, we are of the view that the said reasoning is incorrect. It is reiterated that the IMC Act and the rules and regulations made thereunder, which are all central legislation, have been enacted having regard to entry 66 of list 1 and would prevail over any law made by virtue of entry 25 of list 3 of the Constitution. Hence, in view of the Indian Medical Council Act 1956 and the rules and regulations made thereunder, the Assam Act, namely the ARA 2004, is declared to be null and void in view of Assam legislature not having legislative competence to enact the said law. Consequently, the subsequent legislation, namely Assam Act 2015, that is the Assam Community Professional Registration and Competency Act 2015, enacted pursuant to the judgment of the Guwahati High Court, is a valid piece of legislation as it has removed the basis of the impugned judgment passed by the Guwahati High Court. The 2015 Act is not in conflict with the IMC Act 1956. This is because the Central Act, namely IMC Act 1956, does not deal with community health professionals who would practice as allopathic practitioners in the manner as they were permitted to practice under the Assam Act in the rural areas of the state of Assam. Hence, by separate legislation, the community health professors have been permitted to practice as such professionals. The only meaning is, Malad, as such professionals practicing allopathic practitioners in the rural areas. The said legislation of 2015 is not in conflict with IMC Act and the rules and regulations. Hence, the Act of 2015 is not hit by entry 66 of list 1 of the Constitution and is within the legislative competence of the state. So and so, in the result, so and so, transferred cases 24 and 25 stand dismissed. Pending applications shall disposed of.
What is the effect of Roman 3, 512?
Well, Roman 3 is a declaration which declares two things in my humble submission. A, specific to the Act of 2004. Yes, it is declared to be null. Two, generally, that the legislature does not have to enact the said law.
So what would be the effect of that? That the law which gave them the powers, which conferred them the degree, has been declared null and void.
Correct. Null and void.
Because the state does not have the competence.
On a particular date.
On a particular date.
So, which will, this judgment will relate back to the date of, it must, right?
Enactment.
30/10/2014. So the question is, what happens in the interact now? That's where, Malad, I'm placing some submissions, Malad. I've categorized it under.
I'm just trying to understand the facts clearly.
Lordship, please.
That the 2004 Act was declared to be null and void by the, was interfered with by this court, then to the Supreme Court. Supreme Court upheld that view.
Lordship, please.
For different reasons.
Lordship, please.
But nonetheless, it was held to be null and void.
Lordship, please. But there can be two sets of arguments.
In the absence of state legislature not having the power.
Well, there can be two sets of arguments, and I must be fair to your lordships in my humble submission. The first is, and which I suppose the state will take, that once an act, it is a stop from taking. That's another. That's a subset of my submissions. That once something is declared as null and void, everything under the sun and above the earth goes. There's no effect. Section 6 principles of the general clause is that analogous cannot apply. Therefore, everything that has happened has gone. This could be one view possible, Malad, which will, Malad, lead to, Malad, I may say so, at the outset, honestly, a dismissal of this petition. But the second view could be, and there, Malad, I'm supported by at least 6 judgments of the Honorable Supreme. That, Malad, the declaration of a law to be null and void is always with effect from a particular date. It does not wipe out actions taken, liabilities created, privileges conferred, or rights crystallized under an act which, though declared to be void on a particular day, had its full operation during the time when all of these was acquired. But the first of such question, Malad, was engaging the attention of the Honorable Supreme Court. I straightway, Malad, go to the judgments. Then, Malad, I'll rephrase my sequence.
No, because there's another thing that caught my attention.
Yes, Malad.
There's a new act.
Yes.
Does not talk about repeal of the, doesn't contain any repeal and saving clause.
It doesn't.
Subject to correction.
Yes. Lordship, you're right. Let me check, Malad, since we are assisting your Lordship, let me check one more time. Lordship's impression, and Malad, it doesn't, but Malad, let me, allow me a moment to check. Malad, a sister state had done such an exercise. Malad, Lordship, recall my first submission to your Lordship when I came for the first time, Malad.
Uttarakhand was unclear.
Malad, the parliamentary secretaries, Malad. So there was an act of 2004 declared they had another act. So at the time when Malad, the Honorable Supreme Court was considering, Malad, they came out with a repeal act of a Malad act which was saved by, which was declared void but tried to be reenacted, and they saved all of that. Malad, there are 2 principles. One is de facto and de jure. So many times, Malad, it first engaged the attention of the Grenada High Court. Malad, the question was that, Malad, there was a upheaval. And the people's government, Malad, took power of that state. They had courts functioning. And one of the previous leader was tried for murder. The question was, they delivered judgment. What happens to that? So they said, whatever it is, they invoked the doctrine of necessity, de facto, de jure doctrine, and said that, all right, this is a past transaction. You might have a new constitution, new regime, but all of that need not be affected. Well, in that light, well, your Lordship will recall, we have Article 13 in our constitution, which says 2 things. A, all acts which were in force immediately before commencement of the constitution, which are 2 dates, for certain articles it is November of 1949, but majority 26th of January. To the extent, they are in conflict with Part 3, no, not other portions. Part 3 shall be void. The Lordship may oblige me, and kindly have the constitution. I've given the list of books. The second part is that the state shall not enact any law in future, which is in violation of. So the first question arose before a 7-bench constitution bench of the Honorable Supreme Court in 1951 itself. Please have, Article 13. Laws inconsistent with or in derogation of fundamental rights.
Yes.
May I place clause 1? All laws in the force in the territory of India immediately before the commencement of this constitution, in so far as they are inconsistent with the provisions of this part, shall, to the extent of such inconsistency, be void. So, a constitutional declaration. To the extent of inconsistency, they are all void. 2, clause 2. The state shall not make any law which takes away or abridges the rights conferred by this part, and any law made in contravention of this clause shall, to the extent of contravention, be void. So, here, two constitutional mandates. A, you shall not make it. Two, is a constitutional declaration that even if you have made it, it shall be void. But my lord, your lordship will, my lord, recall the principle, my lord, which Lord Radcliffe in 1956 enacted and, my lord, accepted by our Honorable Supreme Court, all high courts, my lord, in the country, that, my lord, even in respect of a void, invalid, or a null and void order, it bears no seal of invalidity on its forehead. You have to take steps in accordance with law to have the nullity established and have it set aside. And if it is not so done, here it is of course done, my lord, it will be as good as one of the most impeccable orders, my lord, having legal consequences to follow therefrom, my lord. That is, my lord, East Alloy versus, my lord, the Municipal Council.
Which is the principle followed in contempt jurisdiction.
Also, yes, my lord. But 1991, my lord, perhaps, my lord, if my memory doesn't fail me, Justice Ramaswamy accepted that principle in relation to a void disciplinary process, void order of, my lord, discharge or removal from service.
Just one minute. Yes.
My lord, therefore, Article 13 has three different declarations. First, enforce all laws to the extent are void. But, my lord, I cannot take upon it myself to say it's void, I'll not follow. There has to be some declaration.
You have to go to the source who has declared, to redeclare that this is a
blockchain. Now, my lord, what had interestingly happened is, my lord, when the Constitution came into force, and, my lord, Article 13, it was pressed into service by a journalist before the Bombay High Court. He was being prosecuted by, my lord, the erstwhile, my lord, colonial regime in respect of certain, my lord, statements made as a journalist in the press, my lord, etc. And he was being prosecuted under the Act of 35. The contention urged before the High Court was, which the High Court did not accept, that this prosecution has not come to an end. This is the constitutional declaration. Article 13(1) says that act has become void. You cannot prosecute me. The Bombay High Court repelled that contention, dismissed the petition. It came before, my lord, the Honorable Supreme Court. It was considered by 7 honorable judges in a constitution bench. My lord, there are 3 opinions. The majority opinion, then, my lord, Chief Justice Mahajan as their lordship then were concurring with the majority. And there are, my lord, 2 dissents. One by Justice Fazal Ali, dissenting, and, my lord, concurred by, his dissent is concurred by one another honorable judge. Well, that is 1951, if your lordship please has that, my lord.
Is it available here?
No, we have made copies. No, my lord, this was a little research, my lord.
Okay.
This was initially done at the time of filing. That was prepared, my lord. Somewhere it will bear the date also, either in print or something, but thereafter, my lords. 51 judgment. What I've done is, my lord, I put flags to identify the judgments. It is 1951 Supreme Court cases, page 16. Yes, my lord. The other honorable judge was Justice Mukherjee, who concurred with the dissent of Justice Fazal Ali. So please see, my lord, the fact one small
page or paragraph?
No,
Page.
no, it starts at page 16 of the report. Please just, my lord, oblige me by having the small fact recorded as to how the issue arose. My lord, at internal page number, I'm sorry, I have a print, my lord. It will say, my lord, S.R. Das J. That's how it starts. For Chief Justice Kanya, Justice Patanjali Shastri himself, and Justice N. Chandrasekhara Iyer.
That will be around page 25, perhaps.
Because I also have, my lord, a printout on my iPad. At all material times.
Yes.
The petitioner, who is the appellant before us, was Secretary of People's Publishing House Limited, a company incorporated under the Indian Companies Act with its registered office in Bombay. In September 1949, a pamphlet entitled Railway Mazdoor ke Khilaf Nahi Sajish is alleged to have been published in Bombay by the petitioner as secretary of that company. The learned counsel for the petitioner states that the pamphlet was published as a book within the meaning of Section 1 of the Press and Registration of Books Act 25, 1867, and that provisions of the Act have been duly complied with. The Bombay government authorities, however, took the view that pamphlet was a new sheet within the meaning of Section 26 of the Indian Press Emergency Powers Act 1931, and that it had been published without authority required by Section 15(1) of that Act, and the petitioner had committed an offence under punishable under Section 18 of the same Act. Prosecution was accordingly started against the petitioner in the Court of the Chief Presidency Magistrate, Bombay, registered as case during pendency of the proceedings of the Constitution of India came into force on 26/1/1950. On 3/3/50, the petitioner filed a written statement submitting inter alia with the definition of niche sheets as given in Section 26 of the Indian Press Emergency Powers Act 1931 and Section 15 and 18 thereof were ultra vires and void in view of Article 19(1)(a), read with Article 13, and that hearing of the case should be stayed till High Court decided the question of law. This was followed by petition filed in the High Court on 7/3/50 under Article 228 of the Constitution, praying that record of the case be called for. It be declared that Section 15(18) read with 2/6/210 insofar as they create liability for restrictive measure for a citizen are ultra vires Article 19(1)(a) and therefore void and inoperative, and the petitioner be ordered to be acquitted. During the pendency, Chief framed a charge under Section so and so. Petition was heard on 12/4/50 by bench of Honorable High Court consisting of Chief Justice Chagla and Justice Bhavdekar and Justice Shah. Two questions were raised before the bench: whether Section 15(1) and 18(1) read with definitions contained in Sections 2(6) and 2(10) of the Indian Press Emergency Powers Act 1931 were consistent with Article 19(1)(a) read with Clause 2 of that article, and assuming that they were inconsistent, whether proceeding commenced under Section 18(1) of the Act before the commencement of the Constitution could nonetheless be proceeded with. Now, please go, my lord, straightway to where, my lord, concurring opinion of Justice Majan, my lord, as their lordships then were, starts. That should be internal page number 16, about 36 or 37. The majority agrees with the conclusion by the High Court, my lord. Lordships have, my lord. It starts Justice MC Majan concurring. Well, I deemed it appropriate not to, otherwise I was planning to put, my lord, some flags to identify, my lord.
No, you can. It will expedite.
Lordship, but not what was instructed was perhaps, my lord, that will be considered marking then.
No, not before this court.
I'm very grateful. No, it should be page 29. Page 29, my lord, bottom, perhaps, my lord.
Page 29.
Yes, my lord. Bottom has the page numbers.
Yeah, I have.
I also just discovered, my lord. I'm so sorry. 29 or 20? Yes, it should be 20.
Yes.
Concurring. The appellant, my lord, kindly skip that part, my lord, and come with me to paragraph number 29, which your lordship will be pleased to find at page number 32.
Yes.
It gives an impression that it is a contention, but I'll show, my lord, there is a decision on that contention. According to contention of the learned counsel, that's how it starts.
Yes.
Principles applicable to repealed statutes are not in terms applicable to such a case, whether they are to be found in the rules of common law of England or whether they are contained in the Interpretation Act or the General Clauses Act. Those rules are applicable to cases either of repeal or to cases of a statute dying a natural death by efflux of time. None of those, however, have any application to the construction of statutes framed in languages like the one contained in Article 13(1) of the Constitution. Besides the rule of construction which applies to repealed statutes or temporary statutes, our attention was not drawn to any other rule of construction under which a person who commits an offense against an act during its existence as law becomes unpunishable on its termination, both on consideration of convenience and also on grounds of justice and reason. I am inclined to think that the penalties incurred under a law in force at the time when the act was committed would survive its extinction so that persons who violate its provisions might afterwards be punished. Persons who during continuance of a statute have obtained rights under it cannot be affected by a declaration that the statute with effect from a certain date will become an inoperative statute. This is where I lay my emphasis and is elaborated in subsequent judgments. When in the case of repeal of a statute which according to Chief Justice Tyndall obliterates it completely from the records of the Parliament as if it had never been passed, the common law rule has been abrogated by the statute. It is difficult to apply that rule on any sentimental ground at this date to the case of statutes which are declared void or declared to have no effect whatsoever after a certain date only. The expression void has no larger effect on the statute so declared than the word repeal. The expression repeal according to common law rule obliterates a statute completely as if it had never been passed and thus operates retrospectively on past transactions in absence of a saving clause or in absence of provisions such as are contained in the Interpretation Act 1889 or in the General Clauses Act 1897, while a provision in a statute that with effect from a particular date an existing law would be void to the extent of repugnancy has no such retrospective operation and cannot affect pending prosecutions or actions taken under such laws. There is in such a situation no necessity of introducing a saving clause. My lordships put that question to me, that is there a saving clause in the 2015?
No, factually, is there a saving clause or no?
No.
There's no saving clause.
There is in such a situation no necessity of introducing a saving clause. It does not need the aid of legislative provision of the nature contained in the Interpretation Act or the General Clauses Act. To hold that a prospective declaration that a statute is void affects pending cases is to give it indirectly retrospective operation, and the result is repugnant to the clear phraseology employed in various articles in Part 3 of the Constitution. The contention of the learned Attorney General that the phraseology employed in in Article 13(1) of the Constitution clearly indicates that there was no intention to give any retrospective operation to the provisions of Part 3 of the Constitution, and that declaration that laws repugnant to Part 3 of Constitution are void only operates on 26/1/1950 has, in my opinion, force. It seems clear that an existing statute, in spite of a declaration by court that it is void, remains in force till 25/1/1950 and continues to remain on the statute book even after 26/1/1950, except that no effect can be given to any of its provisions which are repugnant to the fundamental rights guaranteed by the Constitution. The effect of Article 13(1) is only prospective. It operates in respect of freedoms which are infringed by the state subsequent to the coming into force of the Constitution, but the past acts of persons which came within the mischief of law then in force are not affected by Part 3 of the Constitution. The reference made by Mr. Chari to different articles of Constitution where saving clauses have been inserted to save pending proceedings or act is not very helpful in as much as where a certain provision has a retrospective effect and it is necessary to introduce a saving clause if things done in the past have to be saved from retrospective effect of the statute. But if the provision is clearly not intended to be retrospective, then necessity of saving clause does not arise. The provisions of the Constitution to which Mr. Chari made reference were of the nature that but for the saving clause, the effect of them would be retrospective in character under the accepted canons of construction of the statute. But what is also important is, I may place, paragraph number 40. 40, which is at page number 35, if I'm not. Reference
Yes.
was also made to the rule of construction laid down by the American courts in respect of statutes declared void because of their being repugnant to the Constitution of the United States of America. Now, here is where I'll emphasis. It is obvious that if a statute has been enacted and is repugnant to the Constitution, the statute is void since its very birth, and anything done under it is also void and illegal. The courts in America have followed the logical result of this rule, and even convictions made under such unconstitutional statutes have been set aside by issuing appropriate writs. If a statute is void from its very birth, then anything done under it, whether close, completed, or incoherent, will be wholly illegal, and relief in one shape or another has to be given to the person affected by such an unconstitutional law. This rule, however, is not applicable in regard to laws which are existing and were constitutional according to the Government of India Act 1935. Of course, if any law is made after 25/1/1915, which is repugnant to the Constitution, the same rule will have to be followed by courts in India and is followed in America, and even convictions made under such an unconstitutional law will have to be set aside by resort to exercise of power given to this court by the Constitution. Then, Malon, well, that's how, Malon, in our courts develop the principle of prospective overruling, Malon, or prospective declarations. Then, Malon, please see a dissent, one paragraph, Malon, I want to place, Malon. It starts at page 37, Malon, Justice Fazal Ali. But, Malon, surprisingly, well, they yes. Just kindly, yes, ma'am. That paragraph is 68. This should be at page number 42. The second argument,
Yes.
which has also failed to impress me, is that if Section 6 of the General Clauses Act does not in terms apply, the principle underlying that section should be applied. The answer to this argument is that legislature in its wisdom has confined that section to a very definite situation, and though it was open to it to make the section more comprehensive and general, it has not done so. It is well known that situations similar to those which arise by reason of repeal of an act have arisen in regard to acts which have expired or the acts which have been declared to be void. And though such situation must have been well known to the legislature, they have not been provided for. In these circumstances, I do not see how the very clear and definite provision can be enlarged in the matter in which it is attempted to be enlarged. Besides, I have not come across any case in which the principle underlying Section 38(2) of the Interpretation Act or Section 6 of the General Clauses Act has been invoked or applied. In Malot, the High Court, but Malot, just see the last 3 lines of 69. Now, that's why I Malot place the dissent as well. Well, the majority dismiss the appeal. The Malot dissent view also dismisses the appeal. Paragraph 69. In my opinion, if the assumption on which the High Court has proceeded is correct, the appellant is entitled to a declaration that he cannot be convicted of the offense which he is accused. In Malot, please see, Justice Mukherjee Malot also saying that I concur with the view. The next judgment, Malot. Now take a leap, Malot, to come back to.
No, sorry, you are referring to 69, para 69.
Yes. In the present case, we have to look at the state of law at the time when the question arises as to whether a person has committed any offense. If we find that the law which made the act an offense has been completely ineffectual and nugatory, then neither can a charge be framed nor the accused person be convicted. In my opinion, if the assumption on which the High Court has proceeded is correct, the appellant is entitled to declaration that he cannot be convicted for offense of which he is accused. So, they say that you can't apply one of the minority view. 38(2) or Section 6 say that you cannot be convicted, but Malot, because of the majority, the appeal gets dismissed. Then Malot, the next decision is
Just like to go back to para 30 again.
Yes, Malot, most certainly. Paragraph 30, Malot. Lordship will have it at page 32.
32, yes.
Well, can I then also, with your lordship's permission, place the last 4 lines of para 29?
20.
29, just
29.
immediately above that.
Yes.
Persons who during continuance of a statute have obtained rights under it cannot be affected by a declaration that the statute with effect from a certain date will become an inoperative statute.
Yes.
When in case of repeal of a statute,
Hmm.
which according to Chief Justice Tyndall obliterates it completely from the records of the Parliament as if it had never been passed, the common law rule has been abrogated by the statute. It is difficult to apply that rule on any sentimental grounds at this date to cases of statutes which are declared void or declared to have no effect whatsoever after a certain date only. The expression void has no larger effect on the statute so declared than the word repeal. The expression repeal, according to common law rule, obliterates a statute completely as if it had never been passed and thus operates retrospectively on past transactions. In absence of a saving clause or in absence of provisions such as are contained in the Interpretation Act or in the General Clauses Act 1897. While a provision in a statute that with effect from a particular date an existing law would be void to the extent of repugnancy has no such retrospective operation. This is where I lay an emphasis. Read with the last 4 lines of paragraph 29. Well, it sounds to my lord equity, it sounds to my lord justice, because
Is it proceeding on the assumption that you pointed out in the last 4 lines of para 29?
That is my respectful submission. I put it in my note, my lord. But otherwise, my lord, it will be too iniquitous, like in the present case, my lord. I tell your lordship, my lord, please apply whatever 3 principles in harmony or hand in glove with each other.
What I want to understand is the last 4 lines in para 29.
Yes, ma'am.
Para 29, last 4 lines, they say, or at least this is what I think I understand.
Lordship, please.
Is that if it is declared to be void from a certain date, it will not take away the rights.
That is what is, my lord, my submission to your lordship also is.
So, in the judgment of the Supreme Court, can we say that it is declared void from a certain date, or is it declared void ab initio? I mean, relating back to the date.
You know, that's where I invoke, that's why, my lord, I brought up that issue, that, my lord, there exists no nullity. My lord, I cannot, as a citizen, ignore the law saying that.
You can also, it can also be said that no, this will only mean when there is a prospective overruling.
No, my lord, that is, my lord, I'll place that one judgment also on prospective overruling. My lord, here there was no question of that, my lord, because this date was certain. My lord, even in the dates of, my lord, judgments of the court, there is certainty.
I have this bad habit of asking questions.
No, my lord. In fact, we are very obliged, my lord, because it helps us to, my lord.
Conclusion. This is basically to understand if we are on the same page.
Lordship.
So therefore, I ask.
I would say, my lord, for any counsel, my lord, practicing on this side is always welcome. We know when the honorable judge, my lord, puts his mind out, he is looking for queries, my lord. There are some gray areas, looking for answers. Ultimately, the goal, my lord, for all of us is to help your lordships, my lord, come to a conclusion as the law as it stands today. So that's the endeavor.
We get the message that councils don't appreciate too much of questions from the bench. So therefore, I must offer my...
No. My lord, with great respect, my lord, and my lord, with all humility at my command, my lord, I on the contrary, my lord, as I said, my lord, if I may take a minute and, my lord, just digress. For the first appearance, my lord, I hail from the complete western side of Gujarat, my lord. Western coast of India, my lord, from the state, and in that also the Saurashtra region. When I first came, my lord, as I had indicated in the first session, my lord, I was before Chief Justice Chalmeshwar, as the lordships then were heading, my lord, as Chief Justice of it. The question was withdrawal of area-based notifications. Exemptions granted, if you come and set up, it will be for 5 years, 10 years, and suddenly, my lord, there was a notification.
Industrial policies.
Yes, my lord. So, my lord, I was faced by a giant, my lord, who had filed a petition, my lord, Mr. Goswami, who was arguing, my lord. new in my endeavor as a law officer, I was here, my lord, because I'd done those matters as a, my lord, small law officer in Gujarat for the union government. So, my lord, I was put a question, promissory estoppel and Motilal Padam. So, my lord, my immediate reaction of the justice was, my lord, that how can you be doing this? I said, my lord, on the same principle which gets reiterated in Godfrey Phillips, which is 1985. What had happened was, my lord, the lordship will recall, in 1974, there was a decision by, my lord, a bench of 4 honorable judges, which held that promissory estoppel will not apply to, my lord, certain legal governmental functions. And it can be held in contract, it can be held in other areas. In Motilal Padampat, my lord, relying on a decision of an English judgment, my lord, which as noticed in 1980 in Jeetram by another bench of Justice I forget the name, in Jeetram, my lord, it was noticed that what was relied upon was a minority, my lord, view. Chief Justice Bhagwati, as their lordships then were, my lord, held in Motilal Padampat, that in all cases, promissory estoppel will apply. Jeetram took a different view. My lord, when this came to the notice, when my lords were the Chief Justice, my lord, of India, the 1980 view was placed. So, my lord, both were 2 honorable judges. So, the principle laid down in Godfrey Phillips was one of the principles that the bench of 2 honorable judges, my lord, could not have disputed or, my lord, disagreed with it had to be placed in accordance with rules of, my lord, propriety before a larger bench. So, my lord, what I argued before the Chief Justice was that if you consider the same principle in Godfrey Phillips on which it is relied, that very principle says that you have to go by the 4 honorable judges, my lord. That is what, my lord, led to the court not being able to, because of queries put to me, the hearing couldn't conclude. And next day was a different bench. So, my lord, I was given the constitutional advice, if I may say so likely, my lord, to tour the city, and I also took the advantage of going, my lord, to Shillong. So, my lord, coming back, my lord,
Yes.
it's my respectful submission that your lordships, my lord, may consider accepting my submission, that, my lord, once it is declared void, it is always from a date. You cannot leave unto, my lord, individuals to come to the conclusion. There has to be a declaration. The declaration under the Constitution can only be by constitutional courts. It has to be from a particular date. My lord, my respectful submission that unless it says, my lord, suppose they say that all degrees, etc., conferred diplomas are held to be void, my lord, that will have a retrospective operation and not prospective operation. But in absence of that relief, my lord, the court is always conscious, my lord, it will not decide upon rights of persons who are presently not before the court. 2, it is in keeping with this principle, my lord, that 26(4) has to be, my lord, construed in my humble and respectful submission of the judgment upholding the judgment of the Honorable Guwahati High Court, of albeit on different reasons, but striking down the act. It will relate back to 3010. But, my lord, 25(4) therefore says, in view of the 2015 Act, where you could not practice allopathy in medicine, my lord, it is saved. That's the only, my lord, if I may say so with greatest respect, meaning which we can, my lord, ascribe or give it to para 25.4. And that is to be viewed in light of the stand of the state also, my lord. A solemn declaration before the highest court of the land. Lord, the next decision, my lord, is 2000. But since I've gone to the decisions, I'll complete this and just then broadly state the propositions and conclude. But 2001. or 2001? 2001, 9 SCC. Page 550 in my copy, please. Question 1 9 Yes,
Yes,
I hope your lordships have that copy.
yes, 550.
Please have para 7. At of the report, page 556. Prospective declaration of a law. Paragraph 7, Malad. Lord, may I take the liberty of asking my colleague to chronologically page 1, 2, 3, 4 so that it's convenient.
Yes.
At the end of the day, Malad, you just do that.
You want to indicate the page numbers?
Yes, so that Malad.
That you can do it on the top of the judgment.
Yes, Malad.
First page.
Yes.
Para numbers or
Lordship, please.
page numbers, whatever.
Lordship, very grateful. This was a claim under the Haryana Urban Development Authority Act. And for that, if your lordship also just kindly peruses. But there was a discrimination between LOTs. And the High Court made classification. Then, Malad, please see para 7. Prospective declaration of a law. Am I with my lords?
Yes.
Is a device innovated by this court to avoid reopening of settled issues and to prevent multiplicity of proceedings. It is also a device adopted to avoid uncertainty and avoidable litigation. By the very object of prospective declaration of law, it is deemed that all actions taken contrary to the declaration prior to the date of declaration are validated. This is done in larger public interest. Therefore, the subordinate forums which are bound to apply law declared by this court are also due to bound to apply such dictum to cases which would arise in future. Since it is indisputable that a court can overrule a decision, there is no valid reason why it should not be restricted to the future and not to the past. Prospective overruling is not only a part of constitutional policy, but also an extended facet of stare decisis and not judicial legislation. These principles are enunciated by this court in Baburam versus C.C. Jacob and Ashok Kumar Gupta versus the state of UP. Otherwise, Malad, what will happen is, Malad, at times, knowingly or unknowingly, without the requisite parties being before the court would pronounce upon the rights without even knowing or without being informed to the court, Malad, that certain rights have either accrued or liabilities incurred or Malad privileges obtained. So that principle, application of that principle will be in accordance with principles of justice, equity, and good conscience, Malad, is my respectful submission. But the next decision is 2022 19 SCC, which I said, Malad, arose from a judgment of this court, Malad, 723. Malad, please note the date of this judgment, 1st February 2022, of the one that I'm citing. In our case, Malad, the upholding of the Guwahati High Court judgment in Malad, the 2004 Act is 2023. So not that it means anything, but perhaps Malad, the lordships had that principle, Malad. The commonality of the bench, Malad, hearing would give that impression, Malad. Malad, here the facts are, Malad, there was a 2000 Act which was challenged. There was a 2012 Act, Malad, which was in peri materia with the 2004 Act. In 2018, the Honorable Supreme Court held the 2004 Act of the state to be unconstitutional. In 2018, in light of the judgment of the Honorable Supreme Court, the Assembly passed a repealing act with a saving clause repealing the 2012 Act, which was in peri materia with 2004 Act. Malad, there was a challenge before the High Court, and the 2012 and 18 Act were held as unconstitutional by the High Court. On a challenge of the said judgment by the state, my lord, this decision was rendered. Well, I am relying upon paragraph 39.1, my lord. And may I just place that, my lord? But before that, my lord, please see page 735. Right and top side, your lordship will be pleased to have the page numbers, para 30. The power at the bottom of the page. The power of a legislative body to repeal law is coextensive with its power to enact a law. The effect of repealing of a statute is to obliterate it completely from the records of the parliament. While repealing a statute, the legislature is competent to introduce a clause saying, saving any right, privilege, liability, penalty, act, deed done, and any investigation, legal proceeding, or remedy arising therefrom under the repeal statute.
You're reading from para
30.
30.
30. I'm so sorry.
Okay. Yes.
Well, perhaps in light of one of the earlier queries, Malak, may I also take the liberty of placing para 28.
28.
It's on the same page, Malak, where 30 begins. An unconstitutional law.
Yes.
Be it either due to lack of legislative competence or in violation of fundamental rights guaranteed under Part 3 of the Constitution of India, is void ab initio. Lordships, I put that query to me. In Behram Khurshid Pesik Kaka versus State of Bombay, it was held by a constitutional bench of this court that the law-making power of the state is restricted by a written fundamental law, and any law enacted and opposed to fundamental law is in excess of legislative authority and is thus a nullity. A declaration of unconstitutionality brought about by lack of legislative legislative power, as well as declaration of unconstitutionality brought about reason of abridgment of fundamental right, goes to the root of the power itself, making the law void in its inception. Then, having said this, paragraph 30. The power of a legislative body to repeal law is coextensive with power to enact a law. The effect of repealing of a statute is to obliterate it completely from the records of the parliament. While repealing a statute, the legislature is competent to introduce a clause saving any right, privilege, liability, penalty, act or deed duly done, and any investigation, legal proceeding or remedy arising therefrom under repeal statute. There is a distinction between declaration of a statute as unconstitutional by a court of law and repeal of a statute by a legislature. On declaration of a statute as unconstitutional, it becomes void ab initio. Saving past transactions are within the exclusive domain of the court. On the other hand, that is why 25.4, that in my humble submission, they are saved. On the other hand, though consequences of the repeal is also obliteration of the statute with retrospective effect on past transactions, the legislature is empowered to introduce a saving clause in the repealing act. Then please go with me to para 39.
Which is not the case here. There's no repealing, there's no saving clause.
Yes, there is no, but Malad, it also, Malad, saving clause will come provided it is a repeal. You cannot repeal something which is declared void. So it is a new act.
No, I mean, not repeal, but says, if it is void, then if it is void ab initio, even a saving clause cannot help it.
But correct, Malad, there will be two, Malad, in my respectful submission, two compartments. A, an act which is still facing challenge and you repeal it. But here is an act
declared void.
Declared void. On the day when the 2015 Act came, it could not have, in my humble submission, I can't go wrong in assisting your lordship, that I, with retrospective effect, repeal that.
There was no intention to repeal that act.
Correct.
When the new act is coming. There are two different compartments.
Of course, Malad, it puts, Malad, every lawyer keeps on thinking at times we get Malad. But such a situation can arise, none to my knowledge, Malad. I must frankly admit. So, Malad, there is a distinction. That's why I placed this paragraph between declaration of a statute as unconstitutional by court of law and repeal of a statute by law. On declaration of a statute as unconstitutional, it becomes void. Saving past transactions are within the exclusive domain of the court.
That's right.
Therefore, Malad, 2015 Act could not have said anything, even on basis of this principle. The only, Malad, court which could have said and which has said in my humble submission is, Malad, while considering the challenge to the Guwahati High Court judgment in paragraph 25.4. Then, Malad, please see paragraph 39. The principles that can be deduced from the law laid down by this court as referred to above are: 1. a statute which is made by a competent legislature is valid till it is declared unconstitutionality by a court of law. Now, I'm going to pause here for a moment.
Yes.
But this would give an impression that but they have in the earlier paragraph which I placed, my lord.
Yes.
Paragraph 28, and that was, in fact, whether it's void on account of legislative competence or abrogation of fundamental right, my lord, is immaterial. They both stand on the same footing. If that is so, my lord, then please read 30. A statute which is made by a competent legislature is valid till it is declared unconstitutional by a court of law. After declaration of a statute as unconstitutional by a court of law, it is non-est for all parties. I place more emphasis here. After declaration. In declaration of law, the doctrine of prospective overruling can be applied by this court to save past transactions under earlier decisions superseded or statutes held unconstitutional. Relief can be molded by this court in exercise of power under Article 142, notwithstanding the declaration of a statute as unconstitutional. Therefore, it is clear that there is no question of a repeal of a statute which has been declared as unconstitutional by a court. Oh, that's the submission that I made. The 2015 could not have said that I repeal the 2004 Act and provide for a saving clause. The very declaration by the court that the statute is unconstitutional obliterates the statute entirely as though it had never been passed. The consequences of declaration of unconstitutionality of a statute have to be dealt only by the court. My lord, please see the difference. Earlier, it says, my lord, that relief by this court, but qua para 40, it says consequences of declaration of unconstitutionality of a statute have to be dealt with only by the court. But that's how this petition is preferred, not for your lordship's decision. Then please see para 44. Having held that Manipur legislature was not competent to introduce a saving clause in the repealing Act 2018, what remains to be considered is the fate of acts, deeds, etc. undertaken by the parliamentary secretaries who were appointed under the 2012 Act. Nullification of, so my lord, may I pause here for a moment? For 2004 Act struck down in 2018, 2012 Act repealed by 2018 Act after the judgment. So in fact, there was no act except the striking down of the judgment. That is why the declaration comes in para 44. But here in our case, what had happened was, is the 2004 Act set aside or declared void by this Honorable Court on 30/10/2014, my lords. Challenge before the Honorable Supreme Court pending. Pending the challenge, my lord, the 2015 Act comes, which, my lord, to an extent saves, my lord, all that, but gives them an equivalence with the same rights, which is why in 25.4, my lord, paragraph 4 of the judgment of the Honorable Supreme Court, those rights get saved. Recognizing the fact that in 2015, the state had legislative competence because it has removed the basis of the judgment. But this declaration in Manipur case was necessary because there was neither 2002 Act, which stood declared void. 2012 Act was repealed by 2018, and this judgment, therefore, I indicated the date. It comes in 2022.
Sorry.
No, please. I mean,
15 Act. At the time when the SLP was being considered, I believe there was some affidavit or some application saying that 15 Act has been enacted, is it?
Well, two things happened. I must tell you, Lordship. I placed that order also. Well, when at one point of time, my Lord the Chief Justice, my Lord, were considering the matter, it was brought to their Lordship's notice, a bench presided over by my Lord the Chief Justice, that the 2015 Act is challenged and those petitions are pending here. Therefore, their Lordships withdrew those petitions, my Lord, in exercise of power and transferred it there. That is why transfer case 2425. Those, my Lord, orders to complete the sequence of facts are placed before your Lordships at pages number in a moment. It will be placed of 2 orders. T 353, yes. My lord, it is an order dated 24/1/2018. My lord, 353, annexure 21. My lord, Chief Justice Bobde, as the lordships then were hearing this matter. My lord. During the course of hearing, 353.
Yes.
We are informed that the Assam State Legislature has passed another law being Assam Community Health Professionals Registration and Competency Act 2015. Pursuant to the impugned judgment passed by the Guwahati High Court on the same subject matter, we are further informed that the state act has also been challenged by way of filing a writ petition being WPC 3914 of 2017, Sudipta Sahu and others versus State of Assam and others, and 6142 Satpal Naik and others versus State of Assam, which are pending before the Guwahati High Court for adjudication. Since the final decision on the issues raised in the instant special petition would directly impact the decision in the aforesaid writ petitions pending in the Guwahati High Court, we issued notices to both the petitioners in those writ petitions and the parties in the instant special petition to show cause why the aforesaid writ petition should not be withdrawn to this honorable court for decision along with the special petition. Then over the page, my lord, on 13/3/2018, 356, heard Shri so-and-so learned counsel for the petitioner in the writ petition pending before the Guwahati High Court, here of the view that WPC number so-and-so Sudipta Shah and WPC number so-and-so should be withdrawn from the Guwahati High Court to be heard in this court along with the present special petitions. We order accordingly the record of the aforementioned writ petitions be transited to this court immediately. Same be furnished to the learned counsel for the parties. Liberty is granted to the parties to file so-and-so. Verbal request of the parties, Medical Council of India shall be added as respondent in all these petitions. Till that time, it was not even there. But it appears. I can't say because none of them are there. It will not be fair. But it appears to me to be a proxy litigation initially filed in 2005.
No, so these two writ petitions filed in Guwahati were putting a challenge to the 15 Act.
15 Act.
And then they were transferred to
They were transferred. That act was upheld, saying that it is not in conflict with the IMC.
Right. By the same judgment.
Same judgment.
Right. So therefore, is it your submission that since the Supreme Court was also in session of the matters and was aware that there was a 2015 Act, therefore, while upholding the order of the
Honorable Guwahati
High Court, setting aside the 2004 Act, and upholding the validity of 15 Act, and 15 Act essentially is categorically reflects that it's for registration of what is that community
health professional and appointed as community health officers
who are defined as persons having degrees in
by virtue of section 3, which I place. Having acquired degree, they shall be deemed by way of deeming fiction.
So therefore, the conclusions of the judgment can only mean that 15 Act safeguards the interest of.
And that is why they specifically put it. In that context, if your lordship may please oblige me for one more time and kindly read with me the conclusion in para 25(4) at page 513. Consequently, the subsequent legislation, namely the Assam Act of 2015, that is the Assam Community Professional Registration and Competency Act 2015, enacted pursuant to the judgment of Guwahati High Court, is a valid piece of legislation as it has removed the basis of the impugned judgment passed by the Guwahati High Court. The 2015 Act is also not in conflict with the IMC Act 1956. This is because the Central Act, IMC Act 1956, does not deal with community health professionals. Now, here comes one of that saving of past. Who would practice, of course, my lord, in future, as allopathic practitioners in the manner reference to the my lord, retrospectively, in the manner as they were permitted to practice under the Assam Act in the rural areas of the state of Assam, which were permitted only by the 2004 Act, not by 2015 Act. That is why this becomes, my lord, very important, my lord, direction in my humble submission. And then the next line to follow. Hence, by a separate legislation, the community health professionals have been permitted to practice as such professionals. My lord, it takes its color from the preceding line. Were permitted to practice in the Assam under the Assam Act in rural areas of the state of Assam. And one of the state also understood it to be correct. I don't know how it went wrong, my lord. I must give to your lordships 2 dates. But the 2 dates are, and there are 2 documents, my lord, to support that submission. For the state, my lord, after the judgment, it by a notification which your lordship will find it at page 515. Immediately next page.
Yes.
This is dated 3rd of April 2023. In pursuance to the Honorable Supreme Court in SLP number so and so with transferred case number so and so in the matter of Barul Islam versus Indian Medical Association, a committee is hereby constituted with the following members to examine the instant Supreme Court case. The committee shall submit a report along with suggestion recommendation within 2 weeks to the Health and Family. They appointed this, my lord. Then nothing was happening, my lord. It seems, my lord, I had made that submission for your lordship's consideration. The government always being impersonal, my lord. There are persons manning the decision-making process. Something somewhere appears to have gone wrong, which only with your lordship's eyes, my lord, judicial eyes can, my lord, discern it from the record.
So what happened in this committee?
My lord, what happened was, my lord, as I'd indicated, though I've seen it, I'd not like to quote it, but there was an opinion by a constitutional authority. Nothing was moving further. We made a representation, page 517, on 3/7/2023, not to complete the complete narration of facts before I came before your lordships. Please just see 517, my lord. With due respect and humble submission, we would like to bring to your notice that we are former rural health practitioners under the erstwhile Assam Act and are now presently designated and recognized under the 2015 Act. Assam Act was struck down by judgment of 3010. Against the same judgment, we had preferred so and so before the Honorable, wherein Honorable Apex Court was pleased to dispose of matter by way of judgment of 24-1. Inter alia by way of following conclusion. This is because the Central Act, namely IMC Act, does not deal with community health professionals who would practice as allopathic practitioners in the manner as they were permitted to practice under the Assam Act in the rural areas of the state of Assam. Hence, by separate legislation, the community health professionals have been permitted to practice as such professionals, copy and close. We humbly state and submit that we have been fighting to save our career and status with best efforts and patience since 2015 in the Honorable Supreme Court of India with the kind and humble support of the government of Assam. After a long period of 7 years, we have finally received a verdict from the Honorable Supreme Court which has recognized our right to practice as such professionals who would practice as allopathic practitioners in the manner as they were permitted to practice under the Assam Act of 2004. In view of the aforesaid conclusion, we request your kind office to implement para 25.4 Supreme Court judgment and bring necessary legislation notification, including but not limited to rules and regulations recognizing our right to practice as such professionals who practice as allopathic practitioners in the manner as they were permitted to practice under the Assam Act, copy and close. Supreme Court has re-established our medical status as well as allopathic status in the recent judgment of 24. So we request the esteemed committee to formulate new regulatory authority or pass an ordinance to regulate these physicians. As we all know, to prescribe allopathic medicine, one must be registered under the Assam Medical Council Act 1999, or his name must be enrolled in State Medical Register to become Registered Medical Practitioner, RMP. Previously, under the RA Act, we were we were registered and had a registration in the state register of rural health practitioners, but it has no relation with the EMC Act. It should be NMC Act 99 Act. So we demand to include us in NMC Act and enroll us properly. The ordinance must contain the medical word by removing previous word paramedical word through amendment. That is little far-fetched, I must admittedly say. Kindly redesignate the unregistered. No, I can't have rights more than 25-4. I must straightway concede to that. Though, I might demand the move. Yeah. But, as your lordships know, in representation, it's always best to ask for everything. But, my right will be confined to what has been provided by 25.4.
Provided by?
Paragraph 25.4 of the Honorable Supreme Court. Sir. So I might have asked for more. Then redesignate unregistered us as registered allopathic health that we can survive with the identity of an allopathic practitioner with designation like additional medical officer. So basically what they are saying is that you have a cadre now at least, because after the judgment you had initiated the process. I invited your
They are now currently working as in contract employment.
Contract employees. And as I said,
community health practitioners.
But what they are asked to do is data entry operations. That's a very sad state of affairs, for the reason it's not, in my humble and respectful submission, it's a human problem. It's also a question, Article 21, person has a right to live with dignity, Now, in that context, if your lordships may kindly, keep in mind Article 19.1. 19.1 says that, every person is permitted to practice a profession of his choice. It is subject to 6. If your lordship sees that for a moment. In my preliminary argument flows from Article 19.6. And another is arbitrariness of the state and the judgment of Varkadas Marfatia, where they've said that wherever in state action there is arbitrariness, the sweep of Article 226 will reach to cure that arbitrariness. All citizens shall have the right, please see, to G, practice any profession or to carry on any occupation, trade or business. This is subject to clause 6. Nothing in subclause G of the said clause shall affect operation of any existing law in force as it imposes or prevents the state from making any law imposing in the interest of general public reasonable restrictions on the exercise of the right conferred by the said clause, and in particular nothing in the said subclause shall affect the operation of any existing law insofar as it relates to or prevent the state from making any law relating to 1. Professional or technical qualifications necessary for practicing any profession or carrying on any occupation, trade or business. I pause here for a moment. The state enacted the law 2004, prescribed that if you want to practice this, we had no control. As I said, that the act of legislature can prejudicially affect no one. It prescribed that you undergo this training, you undergo this course, you undergo this internship, you obtain registration and start practice. Therefore, my right to practice being sacrosanct, was subject to the state law. I had no authority or power or control over enactment of the law. The state comes out with an advertisement after the act is passed inviting applications. Therefore, I meet the threshold to enforce my right under Article 19.1G by saying that in view of the state law, I had acquired the qualification that were prescribed. Nobody objected to it. And my rights have been crystallized, read with Article 21, which is, now that concept has fairly enlarged, the right to live with dignity, the right to be recognized, to continue such practice as was permitted in terms of paragraph 25.4 of the Honorable Supreme Court's decision, of 2023. This right, is the basis. And in support of, it is in support of those rights that I am making an attempt to persuade your lordships that the declaration cannot efface. Let me give an example. Suppose that act permitted me to give certificate of illness and a death certificate. At times we have to place extreme examples to bring the state home to point, my lord. This, my lord. But death certificate was given. It is an exercise of my lord being recognized and registered under that. On that basis, my lord, there is a will which is probated. Can you today say, my lord, that the certificate had no validity because the act is struck down, my qualifications go. Therefore, the certificate is also void, my lord. It will be with great respect, my lord. It can't affect, my lord. And, my lord, please see the intention of the legislature, which, my lord, as we see, my lord, there is separation of powers, my lord. The executive, the legislatures, parliament and state legislature, and, my lord, the honorable courts. My lord, it's the executive which is, I don't know why, feeling shy to carry out the legislative and the court's mandate. For the reason, my lord, that the 2015 Act, the legislature gave us that right, recognized, saying that it is valid piece of legislation, my lord, and the executive sleeps tight over it, my lord. That is what has led to, my lord. And I can understand if acting on that legislation, the state started having special BSc course or some other course.
That has not happened.
It has not happened. Started inviting applications, started appointing, my lord, community health professionals.
Rules framed under the Act.
No, that's one of the prayers. That you have some scheme, some regulation, because what happens is, my lord, therefore, my relief is that direct them to act on those communications of 2015, 2016 after the judgment, my lord, of the Honorable Kavati High Court, where they say that, all right, forward the proposal, we'll have this as RHP. It is, in fact, my lord, a very pitiable condition, my lord, not an emotional argument, but having acquired, my lord, it also amounts to waste of, my lord, public resources. Apart from, my lord, investment of resources by us, my lord. Some of us have become 37, 38, 39, 40 years of age. My lord, from 2005 onwards, my lord, 20 years, we were 17, 18 at that time, my lord. My lord, we had an option to choose. If we wanted to go in the medical profession, A was, my lord, Indian Medical Council Act, B was the State Act. We chose, unfortunately, I would say, my lord. But, my lord, we cannot be today riddled with the, my lord, entire wiping out or, my lord, taking away our acquired and vested right to continue to do what we were trained for. That's why I said, my lord, it's a human problem. Now, the next, my lord, I place this judgment, my lord. The next judgment is, my lord, I placed 2001, I placed 2022, I placed 1951. Then, my lord, 1997, 5 SCC, page 701. Four paragraphs, my lord. 47, 48 to 51 and 54. So the question was, what happens to promotions which are granted? When it was declared, my lord, that this is void or violative of.
These are paragraphs?
Paragraphs 47 to 51 and 54.
Yes.
Lordship will be pleased to find 47 at running page number 242. Bottom of that page, if your lordships have page 242, Mano.
Yes.
The Constitution, unlike other acts. Am I with my lords?
Yes.
The Constitution, unlike other acts, is intended to provide an enduring paramount law and a basic design of the structure and power of the state and the rights and duties of the citizen to serve the society through a long lapse of ages. It is not only designed to meet the needs of a day when it is enacted, but also needs of altering conditions of future. It contains a framework of mechanism for resolution of constitutional disputes. It also embeds its ideals in establishing an egalitarian social order to accord socio-economic and political justice to all sections of the society, assuring dignity of person, and to integrate a united social order, assuring every citizen fundamental rights assured in Part 3 and Directive in Part 4 of the Constitution. In the interpretation of the Constitution, words of which are both a framework of concepts and means to achieve the goals in the preamble. Concepts may keep changing to expand and elongate the rights. Constitutional issues are not solved by mere appeal to meaning of the words without an acceptance of the line of their growth. The intention of the Constitution is rather to outline principles than to engrave details. In state of Karnataka versus Apabalu Ignale at page 485 para 34, a two-judge bench of this court, to which one of us, Justice K. Ramaswamy, was a member, while interpreting Article 17 and 15(2) and Civil Rights Protection Act held, judiciary acts as a bastion of the freedom and of rights of people. Jawaharlal Nehru, the architect of modern India, as early as in 1944, stated that the spirit of the age is in favor of equality through practice, denies it almost everywhere, yet the spirit of the age triumphs. The judge must be attuned with the spirit of her times. Power of judicial review of constituent power has therefore been conferred upon the judiciary, which constitutes one of the most important and potent weapons to protect citizens against violation of social, legal, or constitutional rights. The judges are participants in living stream of national life, steering the law between dangers of rigidity on one hand and formlessness on the other in the seamless web of life. The great tides and currents which engulf the rest of the men do not turn aside in their course and pass the judges idly by. Law should subserve social purpose. Just must be a jurist endowed with legislature's wisdom, historians' search for truth, prophets' vision, capacity to respond to the needs of the present, resilience to cope up with the demands of the future, and to decide objectively, disengaging himself or herself from the very personal influence or predilection. Therefore, the judges should adopt purposive interpretation of dynamic concepts of the Constitution and the Act with its imperative armory to articulate the felt necessities of the time. Must also bear in mind that the social legislation is not document for fastidious dialects, but means of ordering life of people. Then, my lord, with your lordship's leave, my lord, I may go straightway to paragraph number 51. Therefore, it is but duty of the court to supply vitality, blood, and flesh to balance the competing rights by interpreting principles to the language of the words contained in the living and organic constitution broadly and liberally. The judicial function of the court, therefore, is to build up by judicial statements and judicial review smooth social change under the rule of law with continuity of past to meet dominant needs and aspirations of the present. This court, as sentinel on the QE, has been invested with more freedom in the interpretation of Constitution than in interpretation of other laws. This court is therefore not bound to accept an interpretation which retards the progress or impedes social integration. It adopts such interpretation which would bring about ideals set down in preamble of the Constitution, aided by Part 3 and Part 4. So that's why I will also invoke Article 48, and public health in that context. A truism meaning full and living reality to all sections of the society as a whole, making available rights to social justice and economic empowerment to weaker sections, and by preventing injustice to them. Then, please see para 54. It is settled principle right from Golaknath ratio that prospective overruling is part of the principles of a constitutional canal of interpretation. Though Golaknath ratio of unamendability of the fundamental rights under Article 368 of the Constitution was overruled in Keshwan and Bharti case, the doctrine of prospective overruling was upheld and followed out in several decisions. This court negated the contention in Golaknath that prospective overruling amounts to judicial legislation, explaining the Blackstonian theory of law that is judge discovers the law and does not make the law, and the efficacy of prospective overruling at page 80H, plus item D2H. This court, by a bench of 11 judges, has held the doctrine of prospective overruling is a modern doctrine and is suitable for a fast moving society. It does not do away with the doctrine of stare decisis, but confines it to past transactions. While in strict theory, it may be said that the doctrine involves the making of law. What a court really does is to declare the law, but refuses to give retrospectivity to it. It is really pragmatic solution reconciling the two conflicting doctrines, namely that a court finds the law and that it does not make the law. It finds the law, but restricts its operation to the future. It enables the court to bring about a smooth transition by correcting the errors without disturbing the impact of those errors on past transactions. By implication of this doctrine, the past may be preserved and the future protected. The Constitution does not expressly or by necessary implication speak against the doctrine of prospective overruling. Article 32(4) and 142 are designed with words of wit to enable this court to declare the law and to give such direction or pass such orders as are necessary to do complete justice. Declaration of law under Article 141 is wider than the words found or made. The law declared by this court is the law of the land, so there is no acceptable reason as to why the court, in dealing with the law, with supersession of the law declared by it earlier, could not restrict the operation of law as declared to future and save the transactions, whether statutory or otherwise, that were affected on basis of the earlier law. The court is therefore not important to adjust the competing rights of parties by prospecting overruling of the previous decisions in Rangachari ratio. The decision in Mandal case, postponing the operation of 5 years from the date of a judgment, is an instance of an extension of the principle of prospective overruling following the principle evolved in Kolakna. In Managing Director Isil versus B. Karunakaran, a constitutional bench of this court, while overruling, that is affirming, Union of India versus Mohammed Rasam Khan, has held that benefit of decisions would be given only to parties to cases pending before the authorities from the date of the judgment, but not to the actions taken by the date of the judgment. In that behalf, in a separate but partly dissenting judgment to a limited extent on the issue of the need to give benefit to the party that appeals the court in that case, one of us, Justice K. Ramaswamy, has held that as a matter of constitutional law, retrospective operation of an overruling decision is neither required nor prohibited. It is a matter of judicial attitude depending on facts and circumstances. In each case, the nature and purpose of particular overruling decision seeks to serve are required. This court would look into justifiable reliance on the overruled case by administration. All factors, ability to effectuate the new rule adopted in overruling case without doing injustice, whether likelihood of its operation substantially burdens administration or retards the purpose, are to be taken into account while overruling the earlier decision or laying down a new principle. Equally, no distinction could be made between claims involving constitutional rights, statutory right, or common law. The court is required to adjust competing rights, taking into consideration the prior history of the rule in question, its purpose, in effect, and to find out whether retrospective operation will accelerate or retard this operation. Therefore, evolving of appropriate rule to give effect to the decisions of the court, overruling its previous precedent, is one of the judicial craftsmanship with pragmatism and judicial statesmanship as a useful outlet to bring about smooth transition of operation of law without unduly affecting the rights of people who acted upon the law, operated prior to the date of the judgment, overruling the previous law. And therefore, my lord, in the last paragraphs, my lord, their lordships protect all of those promotions, paragraph 63. Then, my lord, once again, my lord, the Honorable Supreme Court was faced with, my lord, when Coelho was decided.
Essentially, you are asking us to interpret a judgment of the apex.
No, my lord, I am only placing this in reliance. My lord, I tell you, lordship, it might at first blush look, but my lord, there could be no other interpretation, my lord, by the state, is my respectful submission. In
Still
any
an interpretation.
No, my lord, because it is clear. My lord, I tell you, lordship, why. My lord, before 2014 judgment, there was no other act. 2015 Act did not permit us. My lord, their upholding of the 2015 Act, which was brought about as, my lord, seen in paragraphs after paragraphs, even 25(4) starts that after the judgment, my lord, this act was brought in, which was with a view to save us, my lord. I say that independently of that, my lord, I am on both planks. That this is the right flowing from the judgment. 2, my lord, even if it were not so, unless, my lord, that's the second, my lord, wing or second, my lord, limb of my argument.
Is one of your prayers a direction to frame the rules?
Yes, my lord. Or a scheme, my lord, or something, because they, my lord, proceeded further with having. My lord, I'll invite your lordship's attention to the prayers at probably 127, my lord, page number. But, my lord, independent of that, I say that even, my lord, suppose paragraph 25.4 wasn't there. My lord, let's take a situation, my lord, for the hypothetical situation for the sake of submission. But even in such a case, till unless there was a declaration that, my lord, all degrees, my lord, normally there has to be a relief granted apart from declaration that all decrees, all rights, etc., will stand, my lord, null and void. It consciously, my lord, neither did the
Even otherwise, since the court had upheld the 2015 Act
lordship, please.
to be constitutionally valid, and 2015 Act also includes or conceives of the idea of including these people.
Lordship. They're deeming fiction under section 3. That
Therefore,
we never applied under 2015. Section 3 says that all those persons who have passed, successfully completed and obtained a diploma in rural health care will be deemed to have been, my lord, registered, granted this degree under this act. I have a diploma or this qualification under this act.
All right. I think we should close for today because there are some
Yes. My lord,
to be delivered tomorrow.
yes. My lord, I then just, my lord, if your lordship just glances the index and I'm done of the judgment compilation.
No other judgments?
No, on this aspect, no other judgment. My lord. Now on the general, what I've done is, my lord, with anticipated leave of your lordships, I have put, my lord, subject words, that this judgment pertains to which subject. Just glance that, my lord.
Have you concluded your arguments or you want?
My lord, just very quickly show, my lord, 2 or 3 judgments, my lord.
Can we continue tomorrow, day after?
Yes, my lord, tomorrow. What subject to your lordships?
Tomorrow after, of course, it has to be after the conclusion of the miscellaneous matters, or day after would be even better.
I leave it to your lordship. Day after, there was some, is declared as miscellaneous day. So, my lord, there's something of another state which has jumped up to that date, my lord.
We'll continue tomorrow.
Subject to your lordship. I'm very.
How much time will you require?
But now, to cite these judgments, my lord, then I'll just place the note, my lord, about 20 minutes. I'll just indicate the maximum 25. But these principles are well known to your lordships.
We'll do like this. We will take a call around 2 o'clock.
Very good.
If we're able to call up, we'll call up. Otherwise, maybe by 3 o'clock, we'll certainly come.
Very good. Very good. Or the only, my lord, anticipatory request is, my lord, will need time to reply. Can my presence be excused? My colleagues will take notes. And they'll, my lord, sit down and each that which is not there in the compilation will just give page numbers.
Yes.
Grateful. Very grateful.
Mr. H. Sarawal, Senior Counsel, assisted by Mr. Adil. I'm sorry, your
It's there in the last orders, my lord. Yeah. Only for the sake of convenience. Last order dated. Your lordships have recorded all of these facts and say that.
And Mr. D.P. Bora. He is for the State Health Department. The counsel for the petitioner has advanced his argument. For further arguments, matter be listed tomorrow. It will be at a lower degree.
I had to show one section, my lord, of 32. My lord. I didn't mention that. Section 32 of the NMC Act. Because that recognizes, my lord, one of the, my lord, state's affidavit I placed before lordships of 2021 as reference.
Tomorrow we'll continue.
Very good. Change. I'm not here. Simple. Issues. That's why I'm not. Web checking. Facebook, it's all here. Thanks, sir. This. Something. Yeah. Yeah. No, you have to follow them. Let me just call them. I have to. ঠান্ডা লাগে গেছে তো মাথা তো অফ করে দে ভালো তো কথা ফের তাহলে কি গেলে জীবন ঠান্ডা না পড় এই এইটা ভারতে তো and as in Nancy, as in home, here as in fathers. Harish Praveen Kant Rahul. Harish Praveen Kant Rahul, wife. This is applied. I have to reach. RIA. Yeah, there are two I email. Gmail. In flower. Yeah, it is. Yeah, it is. Oh. I have wrong, one key. I'm not checking because it was not quite. Yes.